Be cool, be kind, be classy. The cupcakes so sweet and sexy. Have fun and enjoy the journey. Or just have a good attorney. No big whoop, no biggie. She lives near New York City. And not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade. Sipping motions of lemonade. Cool heads will prevail, kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. There's a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack Sack Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish and Latin, it's not just for Manhattan. It's for Goethe and Meshegas. Ridiculous that insanus. Oy vey, Marcus. Proset, that's for schmucks. Be cool, be kind, be classy. My cupcakes sweet and sassy. And not just a YouTube show. When you know. Cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
Good morning, my friends. Today is Wednesday, May 27th, 2026, and today we go to the Mississippi Supreme Court. How's everyone doing today? I hope you're doing well. Hope everyone, I don't even know what day it is anymore. It's Wednesday. It doesn't feel like Wednesday because it's a short week because Monday was a holiday. Even though I was on the air, it's never really a holiday, is it? For, when you're on a breaking news cycle, it's never really a holiday. Happy birthday. Thank you so much, Karen DePasquale, for gifting 5 memberships. You're amazing. So early this morning. And today we're going into the Carly Gregg Supreme Court of Mississippi oral arguments. It doesn't start until 11:30, but I thought we would come in and talk about the issues and give some people who do not know about the Carly Gregg case a little bit of insight into the Carly Gregg case. So many things are happening today, it feels like. So many things are happening. One of the craziest things that happened was yesterday's hearing in the defamation case of the Haas defendants, Jennifer McCabe, Colin Albert, Brian Albert, and Brian Higgins against Karen Reed and Aidan Carney, had a conference in Plymouth Supreme Court in front of Superior Court, in front of Judge Gilday. And everyone thought it was going to be a Zoom hearing, and it wasn't, because the Haas defendants are now moving for a protective order. I haven't seen the papers yet, but I'm assuming it's to keep cameras out of the courtroom, which is so interesting because how many times have I talked about the Afro Man effect? Nobody would have known who those officers were who broke down Afro Man's door and then sued him for making videos about them to make money to pay for the property damage to his house. Nobody would have known who Randy Walters and Pound Cake officer were, but they sued him. And so, they used to call it the Streisand effect. I now call it the Afro Man effect because that's what it is. I want to show you a picture that somebody sent me of the Haas defendants in court yesterday. And, you tell me, but is Brian Higgins unrecognizable? I'm not even convinced that it's him. You tell me what you think. Here they are, trying to keep everyone out of court. Was Court TV there? Did they broadcast the hearing? So this person all the way on the right is purported to be Brian Higgins. I don't know. Maybe he's on the shot. Good for him. Maybe he's on the weight loss shot. Brian Albert, also not looking the same as he did when we saw him testify only 2 years ago. It was almost exactly 2 years ago. 2024 was the first trial. And Matt McCabe, Jennifer McCabe, Colin Albert looks like he's also matured. And then there's Chris Albert all the way on the left. It's crazy. There's a second version of this photograph that somebody sent me, so hang on. Where you can see Brian, if that's Brian Higgins, where you can see his eyes a little bit more. Hold on a sec. And here's that one. I mean, you tell me, what do you think? I don't know who the gentleman is all the way on the right, but he looks spooked. Little Colin got big. Oh, Colin's looking a little more at the camera. He did mature a little bit. Matt McCabe with his typical smirk. It's crazy, right? All right, we are here today for Carly Gregg. I don't know if anybody did broadcast that hearing. I guess they're looking to keep it secret, so we'll see what happens. It's interesting when you sue someone, you can't really expect to keep it secret because, you know, there are such things as courtrooms being open to the public. And I think if you're going to sue somebody, you should expect that it's going to be public. But as we know, these same people have been trying to hide themselves from whatever it is that went on that night at 34 Fairview Road. I don't know if is that their attorney all the way on the end, Tuxbury? That could be. Let's take a look at Carly Gregg's website, which I don't think we've ever done before. So this is a website called, for those of you who don't know, Carly Gregg at the age of 14 shot and killed her mother, Ashley Smiley, and attempted to shoot, well, did shoot her stepfather, Heath Smiley. This was in Brandon, Mississippi. And this goes back to 2024. I mean, it's hard to believe, isn't it? That this trial was in September of 2024, within 6 months of the shooting. Carly Gregg was facing trial. And during the time period when she was in jail awaiting trial on $1 million bond, she was held in solitary confinement 23 hours a day because she couldn't be kept safe, I guess, in Gen Pop. It was that long ago. Yeah, I know. It's hard to believe, isn't it? And today's the day that we're going to hear appellate arguments. Let me quickly flip to the papers because I get talking and then we don't cover what I want to cover with you because I'm like, oh, look, something shiny. I have the appellate briefs here. We'll take a brief look at the briefs. Let's take a brief look at the briefs, shall we? I have way too many windows open. It's getting really drafty in here, but what else is new? Oh, please. Let me know if I freeze because I tried a new thing today. I'm doing an incognito window on the StreamYard because what had happened was no longer StreamYard keeps changing their programming or their platform, but you can't open your StreamYard window in the same window as other windows that you happen to have open on all of your screens because then it will freeze. Carly Gregg was 14 years old when she shot and killed her mother, Ashley Smiley, who was 40 years old at the time, at their Brandon, Mississippi home on March 19th of 2024. The weapon, the firearm, was loaded and unsecured underneath the mattress of Ashley and Carly's stepfather, Heath Smiley, in their bedroom. As her mother lay on the floor, she used her mother's phone to text her stepfather, Heath Smiley, to find out when he was coming home and allegedly lay in wait, attempting to kill him as well. Heath survived. We did a catch-up show the other day. We watched a new law and crime piece on it that pretty much laid out a lot of the surveillance video from that day and portions of the trial, and it was a good recap. If you didn't watch it, you can go back and watch that one for the recap. That was the same day that we talked about Spencer Pratt and the angry moms. I think it was Memorial Day, as a matter of fact. Evidence also showed that Carly called a friend to come over and see her mother's dead body, which was horrific. Carly was 15 when the case went to trial. She was tried as an adult and she was charged with first-degree murder and attempted murder and tampering with evidence because she hid the surveillance camera, I believe the one that was in the living room in the refrigerator. During the trial, the jury was shown a video of Carly's actions before and after taking her mother's life. The defendant, Gregg, asserted an insanity defense, and medical experts testified on both sides. They offered her a plea deal of 40 years, and it was rejected by the defendant. Carly was held in jail in solitary confinement 23 hours a day since her arrest. After 4 days of trial and less than 2 hours of deliberations, the jury returned a verdict of guilty on all 3 charges. And after a sentencing phase, the jury sentenced her. This is weird. In Mississippi, the jury does the sentencing, to 2 life sentences without the possibility of parole. Without the possibility of parole. I'm going to remind you, she was 14 years old at the time of these crimes. And there was really no question that she did it. It was just a matter of, was she legally insane? Was she on crazy medication for a child who had been diagnosed with bipolar disorder, who was hearing voices? She had auditory hallucinations, and many other things that we talked about at the time. She was sentenced by Judge Dewey K. Arthur to 2 life sentences without ever the possibility of parole, plus 10 years for the tampering with evidence charge. Dewey K. Arthur, the judge, ruled that the sentences should run concurrently, which means at the same time. Had the jury found Carly Gregg not guilty by reason of insanity, she should have been confined. She could have been confined to a mental health facility. Her attorneys filed a motion for a new trial. That was denied. An appeal was filed, and the Mississippi Supreme Court has agreed to hear it. And that's what we're going to hear today. Compare and contrast with Mackenzie Shirilla, which everybody's talking about right now. Everybody's talking about it. Mackenzie Shirilla was convicted of intentional murder against 2 victims, her boyfriend and her friend. And she was sentenced by a judge. How old was she at the time of the crime? 17, I think. To concurrent sentences of 15 to life, which means that Mackenzie Shirilla will be technically eligible for parole after serving 15 years. Okay. So this girl who is 14, who had an absolute diagnosis of bipolar disorder, auditory hallucinations. She'd been in and out of therapy since a very, very, very long time. She had major childhood traumas. Her little sister died when she was 18 months old, when the sister was 18 months old. And she was on all kinds of medication that were causing major side effects. And her family, Carly Gregg's family, is standing with her. Her stepfather, her grandparents, the mother and father of her mother, who she killed, are standing with Carly. They do not think that this was Carly. They think it was a psychotic break as well. And so we're going to see what the Mississippi Supreme Court, we're going to at least hear the arguments today and see. Sometimes we can glean from the questions that the justices ask which way maybe potentially they will go. Let's take a look at least the cover page of the appellate brief of Carly's attorneys. And interesting arguments here, because one of their arguments is it categorically unconstitutional to sentence Carly to life without parole for an attempted murder charge? Is that inherently unconstitutional? There is also an argument that any sentence of life without possibility of parole is unconstitutional for a juvenile. Apparently, she is being held in a juvenile facility right now. So at least there's that. So here is the statement of the issues We've been over many appellate briefs before. They have very specific formats that they must use. If you've never seen an appellate brief before, allow me to show it to you. Cover page, they are always bound in certain colors. Appellate printing is very expensive, very expensive. This is the brief of the appellant. In this case, the appellant is Carly Madison Gregg. This is on appeal from the Circuit Court of Rankin County, Mississippi. The defendant requested oral argument. The state requested no oral argument. And not only did the Supreme Court of Mississippi agree to hear it, but they agreed to the oral argument, which I guess is a good sign. They have to include a certificate of all of the interested persons, which they did here, including Carly, all the ADAs, the judge, the appellate counsel, and trial counsel, Heath Smiley, Carly's stepfather. The incident was March 19th of 2024, and she was convicted in September of 2024. Heath also has an attorney, and Carly's grandmother and grandfather. Then they have a table of contents, which lays out the statement of assignment, the statement of the issues, the statement of the case, the statement of the facts, the summary of the argument, and all of the issues, and where the judges can find them. A table of authorities, which includes every single case that they have cited in their briefs, which in this case is almost 4 pages long. Every single statute that they are citing. Secondary sources. Bridget Todd was amazing. She was on my show a couple of times. Remember, Mrs. Bouquet? Were you here that long ago? I think you were. Oh, please. Here is the statement of the issues. Issue 1, the trial court committed reversible error by giving sentencing instructions as to counts 1 and 2 that were improper under the Mississippi Code. Issue 2, Carly's sentence of life imprisonment without parole as to count 2, that was the attempted murder count, is categorically unconstitutional. Issue 3, the trial court erred by not conducting a Miller hearing to determine eligibility vel non. Here's your Latin lesson of the day. Vel non means or not, eligibility or not. It's going to be televised. We're going to watch it together. That's what we're here for. That's what we're here for. It's going to start at 11:30 Eastern. To determine eligibility vel non for life with possibility of parole as to count 1. Issue 4, the prosecutor made improper and highly prejudicial comments during closing arguments relating to parole eligibility. Issue 5, to the extent that Carly's sentence is to be construed as LWOP as imposed by the jury, this sentence was against the overwhelming weight of the evidence and should be set aside. So even if it is constitutional to give her LWOP, the jury still made the wrong decision. Here's part 2. So part 1 was all about the sentencing. Part 2 is about a fair trial. Issue 6, the trial court committed reversible error by prospectively denying any requests for continuance without evaluating the circumstances that might arise during the proceedings. Remember, if you watched it with me, Judge Dewey K. Arthur said, absolutely, you can have no adjournments. I'm getting this case. I'm getting this train on the tracks. I want this case to go to trial. Again, this was a 14-year-old being held in solitary confinement. And at the time, I think that we thought maybe he just really thought that she was going to be acquitted and he really wanted to get her out of jail. Didn't seem to be the case. Issue 7, the trial court erred by compelling psychiatric evaluations absent the findings required by Mississippi law, thereby abusing its discretion and depriving her of a fair trial. Issue 8, the trial court erred when it allowed Rebecca Kirk to summarize the book Crime and Punishment over objection of the defendant. Remember that? When she got to talk about crime and punishment and it really had nothing to do with the case other than Carly said she might want to read it someday. Issue 9, cumulative error requires reversal, meaning based on the combination of all of these things that went wrong, you absolutely need to send this back for a new trial. In contrast, the state's appellate argument is, of course, the opposite, and they did not even want to have, hold on, I gotta take that down and put this up, an oral argument on this at all. Here's the state's brief. Here, oral argument not requested. And here's the state's arguments. Gregg's claim that the trial court committed reversible error by prospectively denying any request for continuance is waived and meritless. 2, Gregg's claim that the trial court abused its discretion by ordering her to undergo psychiatric evaluations is waived and meritless. A, the trial court did not abuse its discretion by ordering a competency evaluation. B, the trial court did not abuse its discretion by ordering a M'Naughton examination. 3, the trial court did not abuse its discretion by allowing Rebecca Kirk to summarize the book Crime and Punishment. 4, Gregg's claim that the first-degree murder sentencing instruction was improper is waived and meritless. 5, Gregg's life imprisonment sentence for attempted first-degree murder is not unconstitutional. 6, the trial court conducted a Miller-compliant hearing. 7, Gregg's claim that the state made improper comments during closing arguments at sentencing is waived and meritless. 8, the Miller factors support Gregg's life without parole sentence for first-degree murder. 9, there could be no cumulative error when there is no error at all. If you're new to this case, there are extensive show notes underneath this video that will catch you up if you have absolutely no idea what this case is about. It was a short trial. What did I say? It was 4 or 5 days. And we did cover this trial gavel to gavel. And of course, the state has the opposite opinion on everything that the defense is now arguing. They did not raise ineffective assistance of counsel as many people thought that they would. And so that's that. Just Lisa G says we need to be talking about the meds. Black box warnings are real. Homicidal and self-deleting thoughts and ideations are real. Yes. And we talked about that a lot during the trial. And no, I am not going to, absolutely not going to have anybody defaming the stepfather. Please do not do that. We don't do that here. Guide your actions accordingly. Yeah, Mississippi is wild. And you know what's also wild to me is how wildly states differ on this issue. In Mississippi, you got a 14-year-old serving life without parole. And then in Ohio, you got Mackenzie Shirilla, who allegedly intentionally murdered 2 people, and she could be eligible for parole in 15 years. It's wild, right? Oh, please. Here's a statement of facts for those of you who are not familiar with the case. On March 19th of 2024, deputies responded to a report of a shooting at 214 Ashton Way in Brandon, Mississippi. Deputy Hunter Lewis testified that he was the first officer to arrive. After knocking several times and announcing himself, Mr. Heath Smiley opened the door and, according to Deputy Lewis, stated that his wife was inside and unresponsive. Deputy Lewis briefly entered, observed Carly's mother, Ms. Ashley Smiley, on the bedroom floor, and testified that he did not detect a pulse. Returning outside and before investigators arrived, Deputy Lewis testified that Mr. Smiley reported that his stepdaughter, Carly Gregg, had shot him and offered a general description of her clothing. He further testified that Mr. Smiley indicated a .357 revolver was on the counter with 1 live round in the cylinder. Deputy Lewis relayed this information to responding units, secured the scene until investigators and the coroner arrived, and remained on site. Here's another thing. In another state, you know, like Michigan or Georgia, would Heath Smiley have been also prosecuted for allowing Carly access to a firearm? She was 14, wasn't locked up. Why did she have access to it? Especially knowing her history of bipolar disorder, auditory hallucinations, changing up the medications, right? And that's why it is so, we cover these cases, because what is justice in one state might not be justice in another state. It would be completely different if she was across the border, right? Although Carly was not at the residence when law enforcement arrived, she did turn herself in without incident a short time thereafter. And the body cam footage of that was chilling. It was like she was in a fugue state. She didn't know where she was. It was very, very strange. Looked like she was in the middle of a psychotic break, which is what a lot of people think. A lot of other people think she was a cold-blooded killer at 14. Nobody knows, because we can't get inside her head. We can't get inside her head. She did look disassociated to me, Robin. And Jenna said she looked so confused. And Mrs. Bouquet says there are parents in jail for exactly that. Sydney says it's the meds. Michael says, and this is a great point, the one constant is that in many of these cases is that the firearms are not locked up and secured. Right. And Karen says, stopping any psychotropic medication cold turkey is so dangerous. Okay, moving on. So she turned herself in without incident. Deputy Tony Shack testified he went out to assist or look for Carly after hearing the call over dispatch. As he was patrolling the neighborhood, he kind of just saw her standing there. She was like in a drainage ditch, as I recall. He hopped out and said, "Are you involved in this incident that happened in this neighborhood?" According to Shack, Carly replied, "Yes, sir." He then took her into custody without incident and transported her to the scene. That body cam was chilling. Other witnesses at the trial of this case were minors. They're referred to by their initials. BG testified he was best friends with Carly. He described Carly's home life as loving. He never saw negative interactions, and said Ms. Smiley was patient, and that Carly's stepdad, got along like best friends. He characterized Carly as a high-achieving genius who rarely got into trouble. Recalling only a single math test incident that left Carly upset and her mother disappointed in a typical way. He did not know of any punishment. He didn't remember details about the phone issue in January 2024. And on the morning of March 19th, this child testified that he saw Carly sitting alone in the cafeteria. After he joked with her and she spilled a drink, she became upset and yelled, and he did not see her again until after school. He told another friend that he was concerned about Carly, and after school, BG stayed in his mother's classroom for a while. In his mother's classroom. Remember, Carly's mother was also, Ashley was a teacher at her school. He got a FaceTime from Carly. He said she seemed upset. He told her not to harm herself or others, and he recalled her saying it was too late. Hang on. Law and Crime has their feed up, so let's see if we can. We'll put that up, and I'll continue to read, because sometimes it takes them a while to get started. Other friends of Carly testified, including BW, who had known Carly since 9th grade, and she and Carly talked easily. They were nice to each other. She went on to testify that she personally had noticed changes in Carly leading up to March 19th of 2024. This child also revealed that Carly called her after school on March 19th, and she seemed jittery and secretive, maybe. BW went on to testify that she eventually went to Carly's residence. I just lost my thought. Where she discovered what had happened to Carly's mom and was told by Carly that she had 3 shots for her stepdad. TG, another student, 17, testified that he met Carly at an MS summer camp in 2022. They kept in touch by phone and Snapchat thereafter. He testified that on March 19th, 2024, on the day of the shooting, Carly FaceTimed him appearing on the verge of tears, scared and frightened, saying she had effed up, but could not bring herself to say what had happened before hanging up. TG said, testified that he was worried that Carly would harm herself. And remember, we didn't see any of the testimony of these kids because they're minors and the cameras have to go off. Heath Smiley is Carly's stepfather, and by his testimony, he had been living with Carly and her mother Ashley since at least 2021, when Carly was in middle school. He described Ashley as a devoted teacher who loved Carly and centered her life around her. Ashley had previously starting. All rise. Please have good.
Oh yay. All persons having business before the court shall draw near and give their attention for the court is now in session. God save the United States, Mississippi, and this honorable court.
Be seated. Mr. Clerk, would you sound the docket, please?
Okay, this is me. This is court. Tell me.
2024 KA.
Am I too loud? Is the court too loud? I have this boosted on 8. Let's see. I may unboost it a little bit. Seems like maybe they have microphones.
1178 SCT Carly Madison Gregg versus the state of Mississippi.
What says the appellant? What says the state?
The state's ready to proceed, Your Honor.
Okay.
Please give the attorneys microphones.
Oops. Murphy, we'll hear from you.
Thank you, Your Honor.
Okay, this is me and the court. Looks like the attorneys are going to have microphones. There are 1, 2, 3, 4, 5, 6 justices on the bench. That's unusual to me because how do you get a majority if you're split 3 and 3? All right, here we go. Carly is allowed to be there. I do not know if she's there. Usually they don't sit at counsel table. Usually they sit in the gallery. So let me know. We'll see if we can see her. All right, here we go.
Oops. Murphy, we'll hear from you.
Thank you, Your Honor. Good morning. Justices, may it please the court. My name is James Murphy, and it is my honor and it is my privilege to be here on behalf of Carly Madison Gregg. Here at the co-counsel table with me is Lance Mixon, and we're both honored to be here as appellate counsel for Ms. Gregg. Now, this case is ultimately about whether a 14-year-old child received the fundamentally fair process the Constitution of the United States and the Constitution of the state of Mississippi requires before a juvenile can be sentenced to the most severe punishment, given the harshest sentence that the state of Mississippi can impose on a juvenile, and that is life without the possibility of parole.
Counselor, let me stop you there. I've read the sentencing order. The sentencing order in this case says that she's been sentenced to life imprisonment, which under the statute, and I think this is consistent with the argument you make on the sentencing issue, the statute on subsection 2 of the sentencing statute for first-degree murder gives 2 options. The jury can do life, can give life imprisonment, and if the jury doesn't, then the judge can assign a term of years. I don't know that I agree with you that this is a life without the possibility of parole sentence. The sentencing statute in subsection 3 seems to say there's life imprisonment. It doesn't seem to say, it does say there's life imprisonment, and then there's life without the possibility of parole or a term of years. So I'm reading this sentencing order, and to me, it's life imprisonment, not life without the possibility of parole. So why do you take the position that the sentencing order, what the sentencing order says is not what the sentence is?
Well, we would agree with Your Honor on that point, and if the state would concede that, I think we could make an easy argument of our sentencing argument here today. But I think the state's position is going to be that life sentence that was imposed by virtue of the parole statute imposes life without the possibility of parole. The jury in this case was given a sentencing instruction that gave them the option of sentencing Carly to life imprisonment or life with the possibility of parole. Now, by virtue of those two options, if they're not giving her life with the possibility of parole, by giving her life imprisonment, they are giving her life without parole. Those are just mutually exclusive options.
Well, I understand there's a separate parole statute in play here. And I can't remember the style of the case, but I know this court's issued an opinion that addresses the interplay between that parole statute and life sentences, life in other contexts. But just strictly speaking, or leaving the application of the parole statute out for a second, there are two options in that sentencing statute: life imprisonment and a term of years. And this sentencing order says a life imprisonment. So I don't see an inconsistency between the sentencing order or the legal sentences under the statute. And since that statute doesn't mention life without the possibility of parole as a legal sentence for this crime, I'm right where I am. I'm struggling to see why this is being interpreted as a life, other than the jury instruction, which admittedly doesn't match the sentence. But what we have in front of us, which is the order of the court sentencing Ms. Gregg, this is a life imprisonment sentence, which is consistent with the statute and doesn't seem to be without the possibility of parole.
And we would, yes, Your Honor, we would agree with Your Honor's interpretation of that. And again, if the state would concede that, we would certainly move on from that argument. But the state has argued in their response to our brief that by virtue of the parole statute, that life imprisonment judgment is in effect a life without the possibility of parole. And as I'm sure Your Honor and the court is aware, the legislature amended the first-degree murder sentencing statute 97-321, amended that statute effective July 1st, 2024, and added a juvenile-specific sentencing structure for both first-degree murder and capital murder. And subsection 2C, which deals with capital murder for juvenile convicted of capital murder after July 1st, 2024, it gives the jury two options, as I think Your Honor would concede. It gives the jury the option of sentencing a convicted juvenile to either life imprisonment or life without the possibility of parole. However, subsection 2B omits that option and only gives the jury the one option of life imprisonment. And I think that goes along with what Your Honor is saying. The first-degree murder sentencing options for a jury in a juvenile case only gives the jury the option of sentencing a juvenile to life. And by virtue of the legislature defining life without, or including life without parole in subsection 2C, and not defining life as life with parole, the only other option is that life imprisonment means life with the possibility of parole. So we would concede, Your Honor, that is the case. In fact, if the court interprets the amendments that way, we would concede that argument.
I had that question too, because the sentencing document says life imprisonment. It doesn't say life imprisonment without parole. And this attorney is saying, yeah, but that's not the way they spoke about it in court. Also, that's not what the statute said. Also, that the statute was changed right before her trial. And if the state wants to come up here and say, oh, we concede she's going to be eligible for parole, then what are we doing here? Right? It is scrolling along the bottom of the chyron that I typed up is scrolling along the bottom of the screen. This is the defense attorney arguing first. They are the appellant.
But from March 19th, 2024, when the incident occurred, until the verdict and sentencing order were rendered on September 20th of 2024, this entire case, the entire case from investigation to indictment to psychiatric litigation to motions filed to motions argued to expert evaluations to discovery to trial to sentencing, it proceeded in approximately 6 months, 183 days to be precise. In a medically and psychotropic medication evidence and dissociation case of this nature, that pace was extraordinary. And the accelerated pace of the proceedings affected virtually every aspect and major issue now before this court. And my first issue I was going to begin with was the sentencing issue, but as the court, I think we've discussed that. If there are any additional questions about that, we would argue certainly that the amended statute does not give a jury the option of sentencing a juvenile convicted of first-degree murder after July 1st, 2024, we would argue that the new amendments do not give a jury the option of sentencing, nor does a judge have the option of sentencing a juvenile convicted of first-degree murder, does not give them the option of sentencing her to life without parole. Now I will transition to the Miller issues. Again, we would argue that the new amendments, they pretty much make Miller obsolete in the context of sentencing a juvenile after the amendments. But assuming that the Miller progeny of cases is still in effect and is still the controlling law when it comes to determining what's proper sentence for a juvenile convicted of first-degree murder, we would propose that the Miller framework was not met in this case. The Miller requires individualized sentencing before a child may be condemned to die in prison. And again, we're operating under the assumption that the state's position is that Carly Gregg was sentenced to life without the possibility of parole. The proceedings here never became the careful, individualized juvenile sentencing hearing contemplated by Miller. The sentencing phase of this case, and again, this case went from the occurrence of the event on March 19, 2024 to the trial on September 16th, concluding on September the 20th of 2024. The sentencing phase, and I'm going to use that term loosely, the sentencing phase of this case consisted of the court announcing the verdict of the jury and then transitioning immediately to asking the state whether they wanted to call their first sentencing witness, to which the state responded that they basically wanted to rest on the evidence that had been previously presented and proceed with argument only. And the defense did the same thing. The defense elected to rest on the evidence that had been previously presented and proceed with argument only. Now, we would argue that this immediate pivot from the announcement of the verdict to the sentencing phase was wholly inadequate in light of Miller. There was no meaningful mitigation development process. There was no opportunity given to the defense to marshal mitigation witnesses. They were given no opportunity to call witnesses, family members, teachers, and as a matter of fact, as part of the pretrial process, the defense listed as one of the potential witnesses the grandmother of Carly Gregg, Miss Vicki Breland, who also happened to be the mother of one of the victims, Ashley Smiley. She was listed as a potential witness, and she was not allowed to testify at the trial. So it stands to reason if she was not allowed to testify at trial, then the question then becomes, would she have been allowed to testify during the sentencing phase? And again, I use that term loosely because there was no meaningful opportunity to conduct a Miller-compliant sentencing hearing. There was no PSI, pre-sentencing investigation conducted, no report. The jury was exposed to confusing and inconsistent parole rhetoric by the prosecution at one point. And again, I'm going back to the sentencing hearing, which consisted of, and it's confusing, the record is confusing as to whether each side was given 7.5 minutes, 15 minutes total for their sentencing argument, or whether they were each given 15 minutes. At one point, it looks like the judge gave one side 7.5 minutes and then the other side was given 15 minutes. So it's not clear to me from the record whether they were given 7.5 minutes to argue the sentencing phase or 15 minutes to argue the sentencing phase. But at one point during the state's argument during the sentencing phase, the state told the jury that if you give her, and again, this is going to the sentencing instruction that they were given the option of life or life with the possibility of parole. The prosecutor stood in front of the jury and told them that if you give her life with the possibility of parole, we don't know when she's going to get out. She might be out, and I'm paraphrasing here, she may be out in as little as a year, which I think we all know is outside the realm of possibility for a life sentence.
She did say that in her closing. I mean, in her sentencing argument. Imagine they're only allowed 7.5 minutes to 15 minutes to argue about sentencing and not call any witnesses. Catherine Newman, I remember this. That was her name, right? Catherine Newman said, you know, if you give her life with possibility of parole, she could be back out on the street in a year. Let's do that again.
Or life will go into the sentencing instruction that they were given. They were given the option of life or life with the possibility of parole.
That's right.
The prosecutor stood in front of the jury and told them that if you give her life with the possibility of parole, We don't know when she's going to get out. She might be out, and I'm paraphrasing here, she may be out in as little as a year, which I think we all know is outside the realm of possibility for a life sentence. But she may be out in as little as a year. And again, I'm paraphrasing, but you may see her at the supermarket, or you may see her at church. You may run into her at any place outside in public. And again, we would argue, and we argued in our brief, that that is improper golden rule rhetoric. It's appealing to the fears of the community, and that is improper. And I understand the state's going to argue, and has argued in their brief, that the defense failed to object to this, but notwithstanding that failure, we would ask this court to analyze that under the plain error doctrine and or pursuant to the ineffective assistance of counsel claims that we've made in our brief.
Oh, they did make it.
We can
It's not
see
the-
no strategic reason why a competent defense counsel would not object to that type of rhetoric argued in a sentencing phase.
A lot of the state's argument is, well, they didn't object to it at trial, and so therefore they've waived that issue on appeal. Apparently, he's saying they did argue somewhere in the brief ineffective assistance of counsel, but we just went through all the arguments and it wasn't in there. So I don't know if it was just a throwaway sentence at the end. We're gonna have to look at the brief after this.
And in addition, even taking into consideration if the Miller progeny of cases is still the law and still applicable to juvenile first-degree murder and capital murder cases, the record is replete with examples of why there were mitigating factors. And we would submit that the juries, and again, assuming they sentenced her, they elected to sentence her to life without parole. And by the way, let me back up, I digress just a little bit. After the prosecution's statements about parole eligibility and when she might be out within a year, and you might run into her at the supermarket, after the jury began their deliberations, almost immediately after they began their deliberations, we know that parole was on their mind and how long she's going to spend in jail if she gets granted parole eligibility, because they submitted a question, and I'm going to paraphrase this too.
Right.
If Carly is granted parole eligibility, if she's given life with the possibility of parole, which is one of the two options she was given by the court, if she's given life with the possibility of parole, how long will she serve years-wise? So we know that was on their mind. We absolutely know that was a question that they had in their mind going into deliberations. Nothing minimizes the horror of what happened to Ashley Smiley or the trauma suffered by Heath Smiley. Nothing minimizes that. But Miller requires courts to distinguish between irreparable corruption, incorrigible youth, and transient immaturity before condemning a child to die in prison. And again, assuming that the state's position is correct, that she was sentenced to life without possibility of parole, that is exactly what she was done. She was sentenced to die in prison, because if she's not eligible for parole at any point, then she will pass away in prison, and that's in effect a death sentence. And I want to read
Mr. Murphy,
from a brief.
Mr. Murphy,
Yes,
let me
Your
just interrupt you there for a second. I want to clarify something for purpose.
For those of you who are not familiar with appellate arguments or Supreme Court arguments, this is the highest court in Mississippi. This is the Mississippi Supreme Court. The justices often ask questions of the attorneys. And being an appellate attorney is a very, very specific set of skills. Appellate attorneys are among the smartest and the highest level attorneys there are, because not only do you need to know every single case that you have cited in your brief, and you saw there were 4 pages of cases listed. You need to know every single case cited in your brief inside out. You need to know the facts inside out. You need to know all of your arguments inside out, and you have to be ready for any questions that the judges may pepper you with. And they just let him speak for an inordinately, in my opinion, long time without interrupting him until now. Many of you love Supreme Court arguments. I do too. I find it fascinating. So in my mind, they let him speak for a long time just now without interrupting him until what apparently is going to be an important question. So let's listen to this.
Brief.
Mr. Murphy,
Yes,
let me
Your
just interrupt you there for a second. I want to clarify something for purposes of I know this court has written that for purposes of the application of that parole statute, the one that forbids parole for people guilty of first-degree murder, we have held in the Miller context that is the same as a life imprisonment. So, but you've still got, I think you conceded, and not just as to those comments that were made by the prosecutor, but also as to the hearing itself and the brevity of the hearing, et cetera. There were no objections made by defense counsel that would have preserved that issue for appeal, were there?
No, Your Honor, there were no objections. And as to that issue, Your Honor, a case that we cited in our brief, Presley v. State, which is 474 Southern 2nd 612, a case that was decided by this court in 1985, a case where the sentence was vacated. And in that case, a pre-sentence investigation report had been prepared and submitted to the court. The trial court offered defense counsel the same as apparently the trial court did in this case, gave defense counsel the opportunity to present mitigation, and defense counsel nevertheless failed to meaningfully develop mitigation evidence. And the court in that case vacated that sentence based on the rationale and the holding that, and I'm going to quote from the Presley court, we recognize that there are cases even where the appellant and his attorney fail to prepare and complete a sentencing record, as was done in this case or not done as the case may be, where the trial court must consider all facets, background, and record in a sentencing hearing in order that a just and proper sentence may be imposed. So we would submit to your honors that this court has the power to impose that duty on the trial court just as it would impose the duty on the defense counsel. And even barring that plain error submission that we are offering here today to give the court the authority to review that, again, I think we've offered the Strickland v. Washington ineffective assistance of counsel claim. We can fathom no strategic reason why defense counsel would not want to ask for time.
Is this court in a position on this record to evaluate the prejudice prong of Strickland, not knowing what mitigation evidence might have been discovered had that work been allowed to proceed?
I believe that we could evaluate the prejudice prong based on what we know about what had been presented earlier in the case. We had two forensic psychiatrists who testified in this case. And I believe even the state's forensic psychiatrist opined that Carly was not a psychopath, that she was not evil, and that she came close, and I'm paraphrasing here, that she came close to the evaluation needed to reach the McNaughton standard. Even the state's own psychiatrist stated as such. And then you had the defense psychiatrist who found that she did meet the McNaughton standard. So the failure of the defense counsel to at least recall those witnesses to testify in the context of a sentencing phase would clearly be prejudicial. To bring out those points that they had made earlier in the proceedings to specifically apply to the sentencing phase, I believe that's absolutely prejudicial, Your Honor. In addition, the issues that I brought up.
Oops, I keep forgetting to turn my mic back on. Let me just remind you of this, that in this case, in Carly Gregg's case, immediately after the jury returned from deliberations and Judge Dewey K. Arthur announced verdicts of guilty as to all three charges and polled the jury to make sure they were unanimous on their findings, the court moved straight into the sentencing phase, like immediately. There was no break. There was no time for a pre-sentence investigation, the way they do in many states. There was no time for victim impact statements. There was no time for anything. It was like, okay, that's it. We're moving right into sentencing. They're also arguing that that too is unconstitutional. And that even if defense counsel didn't object during the things that Catherine Newman said and in front of the court, didn't object, that in the interest of fairness, it should not be use it or lose it because the judge was so unfair moving right into sentencing without the opportunity for any of those things to happen.
earlier, the witnesses, the lay witness, prejudicial, Your Honor. In addition,
Wait, let me just take that back a sentence or two.
defense counsel to at least recall those witnesses to testify in the context of a sentencing phase would clearly be prejudicial. To bring out those points that they had made earlier in the proceedings to specifically apply to the sentencing phase, I believe that's absolutely prejudicial, Your Honor. In addition, the issues that I brought up earlier, the witnesses, the lay witnesses that could have been marshaled and provided, the family members that I believe are here today and that were prepared to testify on behalf of Carly in the sentencing phase, teachers, friends, all of those things, as far as we are aware and as far as the record reflects, they would have all testified on behalf of Carly and would have provided positive mitigation evidence on her behalf.
And again, the argument here in the brief, in the appellate brief by defense counsel, is that the trial court's immediate pivot from the jury's guilty verdict to sentencing, asking the state and then the defense if they wish to call witnesses on the spot, did not satisfy the constitutional requirement for a separate Miller hearing. And for those of you who don't know what a Miller hearing is, it is based on the case Miller versus Alabama from 2012. It's a U.S. Supreme Court case. Miller and its progeny, and I'm reading from the brief right now, require more than a perfunctory inquiry. They mandate a distinct proceeding affording the juvenile defendant a meaningful opportunity to present mitigation evidence, addressing the hallmark features of youth. A hearing where youth and its attendant characteristics are considered is necessary to separate those juveniles who may be sentenced to life without parole. This was not done in Carly's case. By collapsing sentencing into the trial's conclusion and denying defense counsel adequate time to prepare and summon witnesses, the court deprived Carly of the individualized assessment that Miller demands. Remind us of some Miller hearings that you have seen before in juvenile cases in other states. And so the defense is asking that accordingly, because she was not provided the right to a Miller hearing as a juvenile, her sentence must be vacated and the case should be remanded for a constitutionally sufficient Miller hearing. Okay, this is what I do here. I stop and I explain to you while it's ongoing because it's too much to recap everything at the end. I want to do it as we go along. Okay. And so they're saying that Judge Dewey K. Arthur should have conducted a Miller hearing, that she is constitutionally, she has the right to it under the Constitution, and they did not do that here. And somebody's like, why weren't the attorneys prepared? Well, that's why, because juveniles are entitled to a Miller hearing. That's the way it works. Remember, her counsel, Bridget Todd, and her co-counsel did this case pro bono. They represented Carly Gregg for free because they were horrified by what was going on in this case. Here we go.
So yes, Your Honor, we would submit that the record, as far as we are aware, as far as the record reflects, they would have all testified on behalf of Carly and would have provided positive mitigation evidence on her behalf.
He's also saying that even though defense counsel did not object to the lack of a Miller hearing, to the judge going right into the sentencing phase without a break, without the ability to call witnesses, even if they did not object to it, that it should be overturned as plain error by the judge. And they argue that Mississippi appellate courts and the Supreme Court may notice an unpreserved error where the trial court deviated from a legal rule, that is plain error, and that does not have to be objected to at trial, that you, Supreme Court justices, have the right to find that this was plain error on behalf of Judge Dewey K. Arthur, and so therefore it doesn't matter that the defense did not object. There we go.
So yes, Your Honor, we would submit that the record is sufficient to evaluate the prejudice prong of the Strickland analysis. Now, outside of the sentencing issues that we've discussed, Your Honor, the trial court announced at the very first interaction between the trial court and the litigants in this case announced not once, but twice that this court does not continue cases.
He said that.
And it even mentioned that y'all have heard me say this before today, that this court does not continue cases.
Okay, when continue is the same thing as an adjournment. So continuance, adjournment, used interchangeably. He said, yeah, I'm not giving you more time on this. We're going to trial, come hell or high water. Remember? You might remember. If not, he's going to tell you about it right now.
Court does not continue cases. And it even mentioned that y'all have heard me say this before today, that this court does not continue cases. Now that posture shaped the atmosphere of the litigation from the very beginning. Now you may ask, is that in and of itself, is that an abuse of discretion? And we would offer, and we cited Leonard v. Leonard, where a discussion was had of whether a court can issue blanket denials of continuances. And that court held that it is abuse of discretion to prejudge and pre-rule that there are no continuances allowed under any circumstances. And that we would submit that is exactly what the trial court did in this case, announced from the outset that there are no continuances going to be granted. Now the state offered in their response brief that this was not a blanket denial of continuances. This was just an attempt by the trial court to prevent dilatory tactics of the litigants. But Your Honor, looking at the four corners of the transcripts, we saw no caveats issued. There were no continuances unless so-and-so happens. No continuances unless there's a darn good reason. There was none of that. It was a blanket denial of continuances. Well, then the state's going to submit to the court. Well,
Hello, Law and Crime. Is anybody in the control booth? Hello. This is being broadcast on Vimeo, and apparently they're just broadcasting the Vimeo, and I could do that myself. I thought they would have good audio, but again, I don't know what just happened to their screen. Is anybody in the control booth?
the defense never asked for a continuance. So there's no harm, no foul. It's harmless error. Even if it's error for the court to issue a blanket denial of continuances, that error is harmless. But to that, Your Honor, we would offer a plethora of cases, including Mississippi Rule of Evidence 103C, that says no further objection or offer of proof is required where the court's ruling is definitive. Smith v. State, which we cited, 724 Southern 2nd 280, preservation rules do not require actions that would serve no practical purpose.
Without any motion being filed, exactly what do we have in the record where we could say that it was an abuse of discretion not to grant a motion for continuance?
Well, it was not necessarily an abuse of discretion to not grant a motion for continuance, because obviously, as we would concede, there were no motions for continuance.
But I mean, are there any reasons for a continuance? I haven't even heard you argue whether there were any reasons for a continuance that were considered, contemplated, and not requested. You're just simply asking, as a statement of law, for us to find the trial judge in error because he made a statement.
Well, Your Honor, and again, going back to this line of cases that basically says a litigant, a defense attorney, or any attorney is not required to ask for something he knows he's not going to get in order to preserve error. That's exactly what Mississippi Rule of Evidence 103C says. Further objection or offer of proof required where the court's ruling is definitive. There is no requirement.
Counselor, further objection.
Remember, compare and contrast with Edric Faust and all of the times that Ahmad Cruz was told no. That if you fail to object after that and you already know you're going to lose because the judge seems like they're so against you, Mississippi rules say you don't have to object anymore to preserve the record, because we all know jurors can be turned off by that, right? I do remember his pregnant pause. Remember that? Resisting arrest? Yes, I do.
Rule of Evidence 103C says. Further objection or offer of proof required where the court's ruling is definitive. There is no requirement.
Counselor, further objection seems to indicate that there was an objection initially. So I think those cases that you're citing in those cases and the text of that rule still seem to require an initial objection or motion that is denied. I know that Leonard versus Leonard, there was a motion that was denied. That's what the court was reviewing for error, was a decision. So, I mean.
And I think the rules of civil, at least the rules of civil procedure, required that any request made to the court be made by motion, written motion before trial or during trial, and oral motion. And so,
Okay, well, this is clearly not a civil case, Your Honor. This is a criminal case of a 14-year-old. Did you guys read the briefs?
even, I hear your argument, but I don't hear you saying any reason why this was error.
Well, Your Honor, it was error because number one, it chilled the litigants. They I hate to say afraid perhaps, but, and going back to Smith versus State.
I'm not sure anybody was chilled in this case. Just reading the transcript, it seems to me that there was very active participation in this case by the lawyers.
Here's why transcripts are so deceiving. We've been through this before. Remember Judge McCarthy-Nyman? We read the transcript and we said, and I tried to speak to you in my best judge voice of Judge McCarthy-Nyman. We read the transcripts. It didn't seem that bad. And then we got a hold of the recording and we heard the recording and it was so much worse than we thought. Do you remember Judge Dewey K. Arthur and his iron fist and the way that he ruled that courtroom and the glares that he would give? You can't see glares, Your Honor, in a transcript. And it's nice that you read the transcript, but it doesn't tell the whole story.
And certainly there's no reason just reading the transcript. It seems to me that there was very active participation in this case by the lawyers. And certainly there's no reason a motion couldn't have been made, but I'm just wondering, give me some basis for the continuance.
Well, Your Honor, and this is getting into the orders for psychiatric evaluation, which we think were premature and beyond the scopes of Mississippi Rules of Criminal Procedure. The litigants, they were very active, Your Honor. It appears that they were bending over backwards to abide by the court's, for lack of, and I put it in my brief, so I'm going to say it here today, rocket docket announced that this trial is set for trial September 16th, and there's absolutely no reason that we see that this trial can't go forward. So everybody was bending over backwards to accommodate that trial schedule.
As they should, though, isn't it? I mean, that's what we want, is a speedy trial. We have so many cases come through here where it's delayed and delayed and delayed, and now we have one that's moving quickly through the system, which is supposedly the way it's supposed to work. And there's no basis in the record to say a continuance should have been granted.
Well, it was continued.
I'm getting the vibes of like the good old boys club, and I think I'm starting to break out in hives. This 14-year-old was on trial for her life without parole within 6 months of the crime. Her attorneys were 2 solo practitioners who took on this case for free so that Carly would not have to have a public defender represent her, who had the burden of hundreds of cases on their head. And despite the fact that they were doing this for free, there was still only 2 of them. They didn't have massive, high-powered firms behind them like Bob Alessi does. And these judges are like, yeah, shouldn't it be speedy? Her life depends on this. She was kept in solitary confinement 23 hours a day while she was waiting for her trial. And we heard the judge say no adjournments, and he meant it. We're going to rush a kid to trial who's 14 with very complicated psychiatric issues and issues about medication. And thank you for pointing this out. Justice for Carly said earlier, the state was entitled to 3 experts and Carly was only entitled to 1. And maybe it's just me and my hyperbolic self feeling the good old boy vibes here, but that's what I'm getting from them. Let's hear that again. Everybody was bending over backwards to give her a speedy trial. Cool.
Isn't it? I mean, that's what we want, is a speedy trial. We have so many cases come through here where it's delayed and delayed and delayed, and now we have one that's moving quickly through the system, which is supposedly the way it's supposed to work. And there's no basis in the record to say a continuance should have been granted.
Well, it was continuing in a speedy fashion at the expense of Carly's constitutional rights. the trial court ordered her to undergo competency and insanity at the time of offense evaluations before the 17.4 threshold of announcing the insanity defense had been met. And that is simply not what the rules contemplate. And in fact, the defense attorneys in this case filed a petition for interlocutory appeal to appeal that ruling. Her constitutional rights were we would submit, trampled on because they were ordered to turn over privileged information, medical records that they would not have otherwise have had to turn over to the state, but for the insanity defense, which at the time they were ordered to be turned over, had not been properly put before the court. Sure, the defense counsel at one point said that we intend to assert an insanity defense, but with all due respect to all of the attorneys that were involved in this case and even the trial court, none of us are psychiatric or forensic psychiatrists. And so for me as a defense attorney to announce at the beginning of a case before my client has even been evaluated by a forensic psychiatrist, and for me as a defense attorney to say we're going to assert the insanity defense, I believe is malpractice. Because I don't know what an evaluator is going to say once that evaluator reviews all the records and interviews Carly and makes a determination as to whether she has met the Monotony standard. So they were given a Hobson's choice to either turn over those records and waive the privileges that go along with turning over those records, or waive the defense altogether, and they chose to preserve that defense. And until and unless they file the 17.4 notice of insanity defense, the court does not have the power. The court does not have the power to order Carly to undergo psychiatric evaluations at the behest of the state. The court.
Does that apply? Okay, so the state made a motion, as I recall. Correct me if I'm wrong on this, because there's a lot going on in this record.
Yes, Your Honor.
And the court granted the state's motion and sent Ms. Gregg for evaluation, both as to competence to stand trial and the McNaughton issue.
Correct, Your Honor.
But the psychiatrist, counselor, I don't remember which, to whom the court sent Ms. Gregg for that evaluation, reached an opinion as to competency to stand trial, but declined to issue an opinion on McNaughton. Is that correct?
The initial state's expert, yes, that is correct.
All right. Does the fact that that expert declined to address McNaughton or issue an opinion on that affect your argument that it was wrong to send her for that
Well, the
evaluation?
only reason she declined to render an opinion was because there were some issues with marijuana or some other.
Whatever the reasons were,
Right.
does that affect your argument that it was incorrect for the trial judge to
It
order?
absolutely does not affect my argument. That was premature and that was incorrect and outside the court's power to order that exam at that point in time.
And you're saying that the harm that resulted from that is that it gave the defense's strategy up too soon and forced the defense to disclose documents it wouldn't have otherwise yet disclosed.
Among other things, yes. Your
But those documents would have been disclosed because the defense did pursue the insanity defense.
Yes, Your Honor. If the defense had ultimately chose to pursue the defense of insanity, those documents would have been produced. But if the rules had worked the way they're supposed to have, and the timing had worked the way the rules require, then the defense would have had Carly evaluated by their expert who would have reviewed all those records and interviewed Carly and made a determination, yes, she qualifies for the McNaughton insanity defense, then you hand it all over. But if that, in contrast, if that evaluator and that expert had said, no, she does not qualify, then the state does not get the benefit of those privileged documents. The state does not get to have their expert evaluate her. So by jumping ahead and then ordering that the state gets to evaluate her ahead of time, it inverts the whole process. It gives the state access to documents that they may not have otherwise had access to. And with those privileged documents, of course, come waivers of communications that Carly had with her treating physicians and psychiatrists and counselors, among other things. And I think everyone would recognize, I think we'd ask the court to take judicial notice that each evaluation of somebody would affect the next evaluation. And by virtue of the state having the first, I believe the state had the first opportunity to evaluate Carly because the defense's first expert was taking more time to evaluate her than was initially anticipated. And going back to that, they certainly weren't outside of their time limit. According to Rule 17.4, the defense has until the time for filing pretrial motions to assert the insanity defense. And in this case, the court's pretrial motions deadline was August 30th of 2024. The court started pressuring the reports back in June or July of that summer, well before the pretrial motions deadline of August 30th. So the court entered the order July 3rd that she submit to a state expert evaluation.
Okay, Mr. Murphy. Are there any other questions of Mr. Murphy at this time? Okay. All right, thank you, Mr. Murphy.
Thank you.
Okay. Ms. Hartman, the court will hear from you at this time.
I don't know how much time he had total. Did anybody know how much time he was granted? This started at 11:30. It is now approximately 12:17. We stopped a lot. I'm going to say 30 minutes, but I think when they ask questions, I think they stop the clock. So this is now going to be the state's argument. I will change the banner if anybody comes in and they're like, who's talking? What are we doing? What happened? Catch me up. Just tell them about the show notes underneath the video. And the banner scrolling along the bottom of your screen. And here we go.
Mr. Murphy took an additional 9 minutes on his primary presentation, so if need be, the court will also extend additional time to you.
And her clock is set at 30 minutes. There's the answer to my question. I could have just waited 30 minutes, but Mr. Murphy took an additional 9. So if you need it, you can have an additional 9 too. Heather says most attorneys cannot be prepared for a speedy trial in a murder case. 6 months is just not enough time for any attorney to be effective counsel. 100% agree with you.
Your Honor. May it please the court. Good morning. My name is Allison Hartman. I represent the state of Mississippi on behalf of Attorney General Lynn Fitch. This court should affirm Carly Gregg's first-degree murder and attempted first-degree murder convictions and her life imprisonment sentences because every aspect of her trial was fair and no errors were committed in the trial court. Gregg raised several issues related to both the guilt and penalty phases of her trial. Most of those claims are waived because she failed to contemporaneously object or otherwise raise those issues in the trial court. But even if we set the waiver bar aside, all of her claims lack merit and should be denied. I'd like to start with the penalty phase issues because it seemed like that was what the majority of opposing counsel's argument focused on, and then circle back to the guilt phase issues as time and interest allow.
Let's see if they ask the state's attorney as many questions and pepper her with questions and ask her to explain things as much as they did with the defense, which really wasn't a lot. I think there were only maybe 3 questions, 3 or 4. Here we go. Starting with the penalty phase.
It's critical to establish at the outset that Gregg's sentence for first-degree murder is life without the possibility of parole, and her life imprisonment sentence for attempted first-degree murder.
Where do you see in the record that that's her sentence?
Your Honor, we have to look to the parole statute and the sentencing statute.
I understand that the parole statute prohibits parole for somebody who's been sentenced to life. And I understand we have cases that say essentially that means every sentence is life without the possibility of parole in effect. But there's an issue in this case regarding a jury instruction and regarding an illegal sentence. And because of that, I think it's important to see, separate from the application of the parole statute for a minute, what she was actually sentenced to.
So the state is of the opinion that she was sentenced to life without the possibility of parole, despite the fact that that is not what the record says in the body. But we remember because we were there and we heard the arguments. And after we're done here, I'm going to go back to the briefs and I'm going to read you not only the state's attorney's statements during the sentencing phase, but also things that the judge said about not wanting to grant an adjournment. And so he's asking her the same thing because the law was changed in June. I think it was June, right before Carly's trial. So let's hear that again.
Claims lack merit and should be denied.
Okay, she's saying she was sentenced, in fact, Your Honors, to life with ever the possibility of parole. And that's the way we interpret it. And we believe that that is the correct sentence for a 14-year-old. Here we go.
I'd like to start with the penalty phase issues because it seemed like that was what the majority of opposing counsel's argument focused on, and then circle back to the guilt phase issues as time and interest allow. It's critical to establish at the outset that Gregg's sentence for first-degree murder is life without the possibility of parole, and her life imprisonment sentence for attempted first-degree murder.
Where do you see in the record that that's her sentence?
Your Honor, we have to look to the parole statute and the sentencing statute.
I understand that the parole statute prohibits parole for somebody who's been sentenced to life. And I understand we have cases that say essentially that means every sentence is life without the possibility of parole in effect. But there's an issue in this case regarding a jury instruction and regarding an illegal sentence. And because of that, I think it's important to see, separate from the application of the parole statute for a minute, what she was actually sentenced to.
So
And the sentencing statute in this case allows for 2 sentences: life in prison if that's set by the jury, and a term of years. All right, so the sentencing statute, the sentencing order in this case sentences her to life imprisonment. So absent the application of a parole statute, which itself could be amended by the legislature any minute, I don't understand. I get why you say the effect of her sentence is life without possibility of parole, and I think that's relevant to the Miller discussion. But to the illegal sentence and the jury instruction issue, I think it's relevant what that sentencing order says. So what the sentence, you will agree with me, the sentencing order says life imprisonment.
yes, Your Honor, it
And you will
does.
agree with me that that is one of the legal sentences under the sentencing statute.
Yes, Your Honor. So the legal sentence under the statute, the amended statute, like you mentioned, is life imprisonment.
And if the legislature were to amend the parole statute in this next session, I don't have any reason they would, but if they did, and they were to remove the language that says you're no longer eligible for, the language that says you're not eligible for parole if you're convicted of first-degree murder, that's what relevates this effectively to a life sentence we've held. Then all of a sudden she's no longer sentenced to life without possibility of parole. Is that correct?
I think
If it's grandfathered in, if it's retroactive. Trial Queen says, did you watch this trial? This girl is absolutely a danger to society. Well, welcome. You've been subscribed to the channel for at least 3 days, so you're new. You've never commented ever before, but we absolutely did watch the trial. We absolutely 100% did watch the trial. It was almost 2 years ago now. It is my opinion that this girl is mentally ill, that she had a psychotic break, and it is my opinion that a 14-year-old, it is unconstitutional to sentence a 14-year-old to life without ever having the possibility of parole. Compare and contrast Mackenzie Shirilla, who killed 2 people, allegedly, intentionally. She definitely killed them. I mean, they're definitely dead. Allegedly, intentionally, and is eligible for parole in 15 years. So Trial Queen was mentioned. Also, Jen says in reply to that, yeah, we all watched the trial. She's a danger without the proper mental health treatment and help. Yes. In addition to all of the medication she was on and the black box warnings that go with them, and rushing into sentencing without a proper Miller hearing. Listen, every defendant is entitled to a fair trial. To not give this child, this 14-year-old, the time and opportunity to prepare for her constitutionally protected right to a Miller hearing before her sentencing is abhorrent. Here we go. This judge is questioning both of them about the same exact thing. He says the sentencing memo says life in prison, doesn't say without parole. Interesting.
yes, Your Honor, because that's what the court did in Johnson versus State. That was this court. Johnson was originally convicted in 2000, which was pre-Miller, and he was sentenced to life without the possibility of parole, which was under the essentially mandatory life imprisonment without parole sentence pre-Miller. And he successfully filed for PCR, and he received a resentencing hearing in the trial court, and the trial court conducted the Miller hearing, considered the Miller factors, and again sentenced him to life without the life imprisonment. And then this court interpreted that life imprisonment language, which is identical to what we have here, and it considered the parole statute and said that you have to read the sentencing statute and the parole statute to understand what the life imprisonment statute or what the life imprisonment sentence actually is. And that when you consider those two statutes in tandem, essentially under the amended sentencing statute, life imprisonment is life without the possibility of parole. And I think that the court can just look to its own decision in Johnson versus State, which is really instructive on this issue because it's one of the only cases that actually interpret the amended sentencing statute that went into effect in July of 2024. And this court recognized there that you have to read the sentencing statute and the parole statute in tandem to give effect to what life imprisonment actually means. Because as Your Honor mentioned, life imprisonment is the maximum penalty under the sentencing statute. And you have to look to parole eligibility statute to determine what life imprisonment actually means.
In Parker v. State, we held that there should be a determination when that parole statute is in play. It's awkwardly worded, I think, but we said, let me find it, whether or not the defendant should be sentenced to a term of life imprisonment with eligibility for parole, notwithstanding the parole statute. Was there any attempt to instruct the jury on that or to raise Parker before the trial court to try to get a determination that the life sentence should be, notwithstanding the parole statute?
I'm sorry, are you asking whether the trial court should have?
I'm asking whether or not there was an attempt made to follow Parker v. State in the trial court. If you're going to sentence Ms. Gregg to life without the possibility of parole and claim that it's because the parole statute, forbids parole. In Parker, we said there needs to be a determination of whether or not that sentence should be life with the possibility of parole, notwithstanding the parole statute. Mm-hmm. I'm asking you if that procedure that was laid out in Parker was followed in this case.
It was, Your Honor. At the sentencing jury instructions conference, the court and the parties were discussing the sentencing instructions, and there the court was looking at the state's proposed instructions and the defense's proposed instructions. And the court and the parties both acknowledged that under Miller, there had to be a Miller compliant hearing, but also that under Mississippi's sentencing statute as amended, life imprisonment meant life without the possibility of parole. So all the parties recognized that under that first sentencing option in the instruction, life imprisonment was effectively a life without parole sentence.
That's effectively true, but that leads us back to the problem with the jury instruction, which is life without the possibility of parole is itself not a sentence, a legal sentence under the sentencing statute to apply to a juvenile for first-degree murder. It's not listed in statute, correct?
Yes, you're right. I mean, the plain language of the sentencing statute doesn't say life without the possibility of parole. It just says life imprisonment.
And so that jury instruction led the jury to believe, it just didn't follow the sentencing statute because it instructed the jury life without the possibility of parole or life sentence, which in the jury's mind, a life sentence meant, I guess, a life sentence with the possibility of parole, but that's not what the statute provides. In the statute, if you look at the two subsections together, in particular, it's pretty clear that a life sentence means under the statute, life with the possibility of parole. So
I would disagree with that reading of the statute because I think you still do.
Now it sounds like they're in favor of Carly getting parole. A Mississippi woman says, I would not feel safe with this girl running around free in my state. Nobody is suggesting that she go free. Nobody is suggesting that she go free. I do not think that she should go free. I do think that had they found her not guilty by reason of insanity, it was very clearly explained to them that she would be confined to a state mental hospital where she would perhaps get the treatment that she needs. In the current prison system, she's not going to get the mental help that she needs. No one is suggesting that she run free. So let's just, let's clarify that right now. No, I don't think that's what anyone is suggesting here. But this judge seems to be saying, the way I read this statute and the way that the judge explained it, those two things are conflicting. And the way I read the plain language of the statute, life in prison does entitle her to parole. And the way the judge wrote out the sentencing does not say life without possibility of parole. So this is interesting. I'm going to hear that one more time.
Sentence, which in the jury's mind, I mean, it just didn't follow the sentencing statute because it instructed the jury life without the possibility of parole or life sentence, which in the jury's mind, a life sentence meant, I guess, a life sentence with the possibility of parole, but that's not what the statute provides. In the statute, if you look at the two subsections together, in particular, it's pretty clear that a life sentence means under the statute, life with the possibility of parole. So
I would disagree with that reading
laughed.
of the statute because I think you still do have to read the statute with the parole statute in tandem. I know that you're hesitant to concede that point, and I understand, but this court has held time and time again that the parole statute and the sentencing statute have to be read in tandem.
Some people laugh when they're nervous, but I wonder if that old boy judge is going to, and when I say old boy, I mean like good old boy, not that he's actually old. If he's going to take that in an insulting manner, he's going to be insulted by her laughing.
okay, and I might disagree with that because, again, what happens, we've sentenced a few people in this state to life without the possibility of parole because of the parole statute. What happens to the legislature? The legislature has in the past has reformed the parole procedures and the parole, what if the legislature changes that statute and removes that language and all of a sudden makes people who are guilty or found guilty of first-degree murder eligible for parole? Do we have to go back and resentence everybody that was sentenced to life without the possibility of parole because we read the sentencing statute in tandem with the parole statute?
No, I think this court's decision in Johnson versus State indicates that it's the statute that's in play at the time of sentencing. Because even though Johnson was sentenced in 2000, he was
The
resentenced.
sentencing statute.
Yes.
The parole statute is not a sentencing statute. The parole statute is a prohibition on parole.
Right. But in Johnson, this court also considered the parole statute that was in effect at the time that Johnson was resentenced.
Is that the court rewriting a parole statute as a sentencing statute when the legislature clearly intended to govern parole?
I don't think so, Your Honor. I think it's just interpreting what life imprisonment within the sentencing statute actually means. Because in order to determine what life imprisonment means, again, you have to consider parole eligibility. And to do that, you have to look at the parole statute. So the only way to interpret life imprisonment is to look at the parole statute to determine whether or not there is parole eligibility under that statute.
So, Counselor, how do you rectify the fact that one section of the statute says life and the other section says life without parole? Why bother delineating those two sentences in the statute if we're just going to pretend that there's no distinction between them?
I agree.
Excellent question. Excellent question. Somebody said in the chat, don't they write the laws? LOL. No, the judges do not write the laws. They interpret the laws. The legislature writes the laws. That was a good question, but the judges do not write the laws. Their job is to interpret the laws. And that was an excellent question, which is why we're going to listen to him say it again.
Way to interpret life in prison under that statute.
Says life. Counselor, how do you rectify the fact that one section of the statute says life and the other section says life without parole? Why bother delineating those two sentences in the statute if we're just going to pretend that there's no distinction between them?
I agree, Your Honor, that it's interesting that the capital murder provision and the first-degree murder provision are stated differently in the statute.
Do you think maybe that's because the legislature intended them to be handled differently in reality, in the world, in life, in court?
Possibly, Your Honor, but there is a distinct difference between capital murder and first-degree murder. We tend to look at capital murder as more severe, but first-degree murder requires deliberate design, intent, premeditation. Capital murder doesn't require that. It could
You can be convicted of capital murder without actually murdering anyone.
That's right. So
why do we make that distinction where somebody who does something that's not even as bad as murder or killing someone gets life without parole, and it's delineated in the statute, life without parole, but now you're standing here saying, oh, well, just ignore the fact that the section right above it just says life and doesn't add without parole. That's disingenuous, Counselor.
No, Your Honor, I'm not trying to say ignore that. I'm trying to point out the difference between.
Oh, he just called her disingenuous. Judges getting upset. Judges getting upset. They don't have name plaques, I don't think, or at least I can't see them from here. He's like, how dare you? We have a how dare you emoji. I don't know. I feel like he's on Carly's side. Hold on. I want to hear that again. Tell her, Judge, how dare you? Stop laughing. I think he's also like, stop laughing. He's salty, right?
Without actually murdering.
Capital murder doesn't require that. It could
You can be convicted of capital murder without actually murdering anyone.
That's right. So
why do we make that distinction where somebody who does something that's not even as bad as murder or killing someone gets life without parole, and it's delineated in the statute, life without parole, but now you're standing here saying, oh, well, just ignore the fact that the section right above it just says life and doesn't add without parole. That's disingenuous, Counselor.
No, Your Honor, I'm not trying to say ignore that. I'm trying to point out the difference between the two provisions. And the capital murder portion of the sentencing statute also provides for the option of life with the possibility of parole, where the first-degree murder sentencing provision doesn't provide for the life with the possibility of parole. So I think there is an intentional difference there in creating an avenue for parole eligibility within the sentencing statute for capital murder.
But you're treating them the same. That's my point. Thank you.
Okay. Yes, but Your Honors, I think that if this court looks to Johnson versus State, it's very instructive on how this court should deal with this issue here today, because there, again, the court dealt with this exact sentencing statute and the parole statute. It read them in tandem, and this court said that under the sentencing statute, the language life imprisonment under subsection 2B, which is the subsection we're operating under, life imprisonment means without parole when you give the parole statute consideration. And that's what this court said, is that you have to consider the parole statute, and that once you consider the parole statute, life imprisonment in subsection 2B is without parole. And that's how, in this case, we know that Carly Gregg's life imprisonment sentence is without parole, and it's not with the possibility of parole. And kind of going hand in hand with that, Carly Gregg's jury had the discretion to impose a life imprisonment sentence, or if it couldn't reach that, then let the judge decide the penalty. And that's consistent with the United States Supreme Court's holding in Miller, which required an individualized sentencing hearing, after which the jury or the sentencer considers the Miller factors before imposing a life in prison sentence. And neither the Supreme Court nor this court have ever laid out step by step exactly how a Miller hearing is supposed to be conducted. If you look to Montgomery versus Louisiana, for example, or Chandler versus State in this court, or McGilberry, the Supreme Court and this court both say that the defendant has to have an opportunity to present evidence to support the Miller factors, and that the jury or the senator, because it could be the trial court in certain circumstances, consider the youth and its attendant characteristics using the Miller factors. And that's what happened here. Gregg had the opportunity to present evidence on the Miller factors, and her defense trial strategy was to focus on allowing the judge to sentence her instead of the jury, because the sentencing authority of the judge was only 20 to 40 years. So I think her trial strategy was clear, to hope that the judge would sentence her, not the jury, so that she could get a lesser sentence. But the jury instruction, SS1, which is at the clerk's papers 1093 to 1094, it lays out the Miller standard clearly, and it says it instructs the jury what the Miller factors are, and it instructs the jury to consider those factors in determining whether or not it should sentence Gregg to life imprisonment. And that, in effect, was the Miller hearing. Just because Gregg now says that she wished she presented more evidence doesn't mean she didn't receive everything that she was entitled to under Miller, which was a separate individualized sentencing hearing, and the jury considered the Miller factors and exercised its discretion to impose life imprisonment instead of letting the judge decide her punishment. And I think, circling back a little bit, I think on the jury instruction issue, it's also crucial to recognize that Gregg not only didn't object to the state's proposed jury instruction, which is SS1, but she actually withdrew her own proposed instructions and acquiesced to the state's instructions. So I think that goes beyond waiver, and the fact that Gregg agreed to those sentencing instructions, and now she can't come back on appeal and claim that the trial court erred in giving those instructions because she agreed to them. As I mentioned, Gregg received everything she was entitled to under Miller. That individualized sentencing hearing, the jury considered the Miller factors, and the state presented sufficient evidence on each of the Miller factors to support the jury's verdict. It submitted evidence on her chronological age and how her maturity level, education level, ability to maintain relationships overcame her young age, which was 14. Her family and home environment. She had a tough upbringing in the beginning, but once she moved out from her biological dad's house, for all intents and purposes, she had a great home life. Her parents supported her hobbies. They took her to guitar lessons, karate. They supported her academic success, and most notably, when she expressed any issue with her mental health, they immediately took her to get psychiatric and therapeutic help. And then the other Miller factors, the circumstances of the homicide offense. Obviously, the jury here heard significant evidence about the horrific nature of the murder. It heard and saw photos where Gregg shot her mom 3 times point blank range in the face. So obviously that the circumstances of the homicide offense weighed in favor of the life imprisonment sentence. So this court should affirm her sentences because she had a Miller compliant hearing, the jury instructions adequately tracked the statute, and the state submitted sufficient evidence to support the imposition of the life in prison sentence. And I also want to briefly touch on Gregg's claim regarding the prosecutorial misconduct.
Let me ask you to back up. Your comment about the jury instruction adequately tracked the statute, and I hate to keep coming back to this, but the statute, when you say the statute, the sentencing statute does not have an option for life without the possibility of parole.
Yes.
It does not have that possibility.
That's right.
So when we're in a situation because of a case from this court, the Johnson case, the cases where we've basically held that effectively every life sentence is without the possibility of parole, so we might as well go ahead and sentence them to that. But we're in a situation where we're trying to work with that precedent from this court, can even make the argument plausible that a jury instruction that flat does not track the language of the sentencing statute itself tracks the language or tracks the law. Doesn't that seem like a problem for you, where we can't actually track the sentencing statute that the legislature chose, which, by the way, these amendments took place after Johnson. They took place after Miller.
Mm-hmm. Yes,
that doesn't seem like a problem to you, that we have to actually not track the statute to track the statute?
Well, I think the sentencing instruction did track the statute, and that it said life imprisonment was the option, not life without the possibility of parole. So it didn't actually, the sentencing instructions didn't actually say life without the possibility of parole. It just said life imprisonment, and that's what the jury sentenced Gregg to. Then we know that's without parole because, again, going back to the parole statute, which says that first-degree murder is not a parole-eligible conviction. So technically, Your Honor, the instruction did track the statute, especially when you consider the parole portion of the statute. If Your Honors don't have any more questions about the penalty phase of Gregg's trial, I'll move on to the couple issues that opposing counsel raised regarding the guilt phase. First, in regard to Gregg's argument that the trial court prospectively denied all motions for continuance, I think that's a stretch to say that the trial court expressly denied any motion for continuance. This was during a status conference where the parties were discussing deadlines and how the case was scheduled in terms of proceeding forward, and the court just expressed his general dislike for continuing cases. But it's critical in this case that Gregg never moved for a continuance. She never sought more time. She never indicated that she needed more time to do anything. So there was nothing really right for this court to consider because there was no denial of any motion. So we would just argue that she waived that claim and that there's no decision for this court even to review in regards to the, quote, prospective denial of motions for continuance. Turning to the Monotone issue, really Gregg argues form over substance here, because the truth of the matter is that from the beginning of the pretrial hearings, the scheduling conferences, status conferences, she repeatedly indicated that she intended to pursue the insanity defense. We cited in our brief a thorough account of all of the instances where she expressed her intent to pursue an insanity defense to the trial court. And we would also refute her contention that the state had the first chance to have her evaluated. It was the court who appointed Dr. Gugliano originally to evaluate Gregg for both competence to stand trial and monotone insanity. And as Your Honor recognized earlier, Dr. Gugliano did not feel comfortable proceeding in doing a monotone evaluation based on the fact that Gregg was on some drugs and that there was some medication history in regards to what she was prescribed. So after that, Gregg hired her own expert, which was Dr. Webb, to conduct her evaluation. She ended up not using Dr. Webb, hired Dr. Clark, who had the first opportunity to evaluate her, and he just wasn't finished with his evaluation when the state's expert, Dr. Pickett, began his evaluation. And importantly for this point, again, is the fact that Gregg didn't object to any of this occurring. There was never a point in time where the trial court said he was going to appoint experts to conduct monotone evaluations, that Gregg said, no, we object to that. We don't want her evaluated. We're not going to plead insanity. Her only request at any time was that her expert evaluate her before the state's expert. But even when the state filed its formal written motion seeking to have her evaluated under monotone, Gregg did not object. And in fact, in the trial court, it asked, do you have any objection to the state's motion? And they said, no, Your Honor. So I think that any argument she makes that she should not have been evaluated under monotone before filing her 17.4B notice is really mooted by the fact that she herself acquiesced to being monotone evaluated even before filing that 17.4B notice. Your Honors, if you don't have any further questions on any of the issues, then the state would rest on its brief and urge this court to affirm Gregg's convictions and sentences.
Any questions for Ms. Hartman? Thank you, counsel.
Thank you, Your Honors.
I mean, it seems to me like the
All right, Ms.
justices.
Murphy.
Hold on. Are hanging on the plain language of the statute, and that's a good thing for Carly.
Please, the court.
Because any ambiguity should run to Carly's favor. And that's what it seemed to me. Tell me what you think. This is now going to be the rebuttal by the defense. Thank you, Love My Flip-Flops, for gifting 5 memberships. You're the greatest. I love you so much. And to the 5 new members who were gifted, welcome. Let's go to the rebuttal. Hold, please. Thank you. Okay, here we go. Let me just change the banner. Go to the chat for a moment before we get on to rebuttal. So Raven said earlier, and I started this earlier, having had some experience with those that have bipolar, sometimes they voluntarily stop medication thinking they don't need it. In this case, if she were to go free, that would concern me. And this was earlier, so I just wanted to remind you that no one is suggesting that she go free at all. Moving on. Ms. Scarlett, I think this was in reference to Mackenzie Shirella. Per local lawyers, no one there gets parole after only 15 years. No one. I'm just pointing out the difference in sentencing for minors, even if they're tried as adults, from state to state. This is Ohio versus Mississippi. Law and Disorder said, I'm so sick of parents claiming mental health issues when their child goes rogue. I raised kids. Yes, some do have issues, but parents need to parent. I have 5 kids of my own, and I'm going to assume from your comment that you didn't watch this trial, but Carly's grandparents, the parents of her mother, whom she killed, stand behind Carly, and they say this was out of character for Carly. It was these crazy medications these doctors had her on. She's been hearing voices since she was a child. She may or may not have been abused by her birth father. He forced her to watch him do drugs and had her chugging beers when she was 12. It goes far beyond just her parents making up some mental health issues, like you may be thinking of maybe the Mackenzie Shirley case. That is not this case. Okay, let's get back to the rebuttal. Thanks.
I'd like to address a couple quick points, if I may, before I move on to some more substantive argument. I believe it was Justice Sullivan who asked counsel whether the legislature could have, whether it's possible that the legislature intended for life in subsection 2B as it applies to juvenile first-degree murder, whether the legislature could have intended that that be life with parole irrespective of the parole statute, and counsel responded, possibly. I think that is very telling, and that I think at the very least, while we would assert that it very certainly does indicate that the legislature intended that, but we would assert that the state has now conceded at the very least that there is some ambiguity as to whether the state or the legislature intended that or not. And as I think the court is well aware, the brief that we cited, we included all of the canons of construction when the court is interpreting statutory construction, and one of those rules is the rules of leniency. And the leniency rule states that if there is a distinction to be made, if there is an ambiguous statute, and there are two interpretations, the interpretation that is most lenient to the defendant is the one that the court must adopt. And in this case, that adoption would be that the statute that was amended and in effect at the time of the sentencing is that Carly's sentence is life with the possibility of parole. I'd like to make that quick point. And also, Your Honor, I'd like to address, Your Honors, I'd like to address the state's reliance on Johnson v. State. 2 points I'd really like to make about that and why the state's reliance on that is misplaced. Number one, I believe it was Justice Coleman who pointed out that was decided well prior to the amendments to the statutes and in response possibly to Miller. But that case involved a very thorough Miller sentencing hearing. And that is distinguished from this case because there was no Miller sentencing hearing. There was, and again, I've used that term loosely, there was a sentencing hearing, but that was very, in effect, it was a sentencing argument. So in the case at bar, unlike in Johnson, we had no sentencing hearing. And I believe Miller not only stands for the proposition that there are certain factors that a jury or a trier of fact or whoever's deciding the sentence must consider. You can't just throw all these factors that the jury must consider at the wall and assume that they're going to consider them. So there's a substantive aspect to Miller, but there's also a procedural aspect to Miller. In other words, is the defendant given adequate process, adequate notice, and an adequate opportunity to address those Miller factors? And in this case, there was absolutely no notice that we're moving into the sentencing phase. I'm not even sure prior to the court turning to the state and saying, present your first sentencing witness, I'm not sure whether the litigants were even aware that that was going to happen.
We're going to watch the sentencing phase again after we're done here, because I think there are a lot of people in the chat who have no idea what they're talking about. It's wild to me how so many people can come out, especially like this whole Mackenzie Shirella thing, after just watching the documentary, not watching the trial, with such strong opinions about a person they don't even know. It's crazy to me. And the same thing, I see it going on here in the chat. I think there's a lot of people who didn't watch the trial, and they are coming in and it's just like she should spend the rest of her life in prison. She's a psychopath. It's wild to me. So we're going to watch the sentencing again. It's only about an hour long after this is over. Yes, this is a Dave Matthews hat because summer tour is here and I'm so excited. Dancing Quinn says, God bless all the self-righteous parents in this chat. You really are out of touch with the seriousness of some mental illnesses and lack of proper health care. Here we go. Moving on.
Certainly don't see anything in the record where the sentencing order or anything like that outlined that was going to happen. But certainly the defense was not afforded any due process to address those Miller factors. And so we would move or posit that Johnson is really inapposite to Carly's case. Another issue that we would point out, and I'm just going to read from our brief, the state's reliance on Johnson v. State is misguided. According to the state, and I'm quoting from the state's brief, this court held in Johnson that the trial court's application of section 4773 to sentence Johnson, who was 17 when he committed first-degree murder, to life imprisonment without the possibility of parole after a Miller hearing was not an abuse of discretion. Thus, in harmony with Miller, section 97.321(2)(b) allowed Carly Gregg's jury to sentence her to life without parole, consistent with section 4773D, which is a parole statute, but only after it considered the Miller factors. However, the trial in Johnson occurred in 2000, as I think Justice Coleman and Justice Sullivan and perhaps a couple of other justices pointed that out. The trial in Johnson occurred in 2000, nearly 2.5 decades prior to the amendment to 97.321 from Senate Bill 2022 of our 2022 of our legislature's regular session in 2024. And now, if I may, we did not address this in the initial argument, but I would like to address one of the errors that we have alleged that the defense did object to, and that was the introduction of the crime and punishment summation by Rebecca Kirk, who was one of Carly's counsel.
Yes, let's talk about crime and punishment for a moment, because this is one of the things that I vividly remember from the trial, how Rebecca Kirk, who was one of the she was a mental health provider of some kind. I don't remember exactly if she was a medical doctor or if she was a licensed social worker or a therapist of some kind, talked about Crime and Punishment, the book, and was entitled by Judge Dewey K. Arthur to go on about the plot of Crime and Punishment because it was underlined in someone's notes. But the only reason it was underlined because it was a book title. And that's the way many of us were taught. Our kids don't even handwrite anything anymore. But back in the day, we were taught that when you reference a book title in your writing, you underline it. So let's listen. She was a nurse practitioner. Thank you, Justice, for Carly. And that is no shade to nurse practitioners at all, but they do not have medical degrees. Okay. They are not forensic psychiatrists. You have to watch the actual trial. In my opinion, too. Thank you, Deb Vitt. All right. Let's hear what he's got to say about the crime and punishment issue.
During the state's rebuttal case, the state elicited testimony from Rebecca Kirk, who was, again, one of Carly's counselors, to summarize. Well, first she was asked what books Carly had read or was going to read, and there were several books that were mentioned. One of them was The Bell Jar, another was The Castle, and then there was Crime and Punishment. Curiously, the state did not ask Rebecca Kirk to summarize The Castle or The Bell Jar. The only one that they asked Rebecca Kirk to summarize was Crime and Punishment. And this was over objection of defense counsel. And this was over objection of defense counsel after pointing out to the trial court that there's no proof that Carly even read the book at the time of the trial. Now, we would dispute whether or not that was ever established. I think.
And she didn't read the book. She didn't read Crime and Punishment. She was a voracious reader, and we had an Amazon list for her. And I think you guys bought every single book on that Amazon wish list for Carly while she was there reading. She scored 30 on the ACT at age 13. Very smart child. In cross-examination, I think defense counsel got Ms. Kirk to admit that maybe she said she was going to read it, but she hadn't definitively read it or not. But whether she had read the book or not is really irrelevant. The plot of that book was a sensational plot that, as summarized by Rebecca Kirk, it was about a hatchet-wielding murderer who tried to assert the defense of insanity and then got away with it and was unremorseful and unrepentant. That was the summation of Rebecca Kirk. Now, not only would we assert that that was an incorrect recitation of the actual book, but at the very least, it was the important points that Rebecca Kirk remembered about the book. It was not the important points that perhaps Carly Gregg would have remembered about the book.
But be that as it may, the only reason that the prosecution would want Rebecca Kirk to summarize that book is because the prosecution wanted that jury to hear those sordid details about that book and associate those details with Carly Gregg. They wanted the jury to think, well, if she read that book, she must have been she must have had those thoughts, and she must have hatched the plot to plead insanity after she read that book. That is exactly what the prosecution wanted the jury to believe, and that was over the objection of the defense. Now, I believe it was Justice King, and I believe Justice Coleman joined Justice King in an objection in Jordan v. State, which was an en banc split decision by this court rendered in 2016, which was reviewing a affirmation of an appellate court. The Court of Appeals affirmed a finding of guilt after the prosecution was allowed to introduce rap lyrics. The Court of Appeals affirmed the conviction, and then the Supreme Court was split evenly 4-4. Again, I think Justice King filed an objection. Justice Coleman, I believe, joined in that objection. And there were several things that Justice King cited in his objection. And I believe that court cited with approval a New Jersey case, State versus Skinner. In that holding, in State versus Skinner, the New Jersey Supreme Court held that lyrics were highly prejudicial and carried little or no probative value because they were expressive, fictional writings and not tied by a strong nexus to the charged shooting in that case. Just as in this case, there is no nexus between what the writer of Crime and Punishment wrote and what was alleged that Carly did. There was no nexus. It was not even established that she had read the book. And I want to read a quote because I think it's extremely instructive from State versus Skinner. The difficulty in identifying probative value in fictional or other forms of artistic self-expressive endeavors is that one cannot presume that simply because an author has chosen to write about certain topics, he or she has acted in accordance with those views. One would not presume that Bob Marley, who wrote the well-known song, I Shot the Sheriff, actually shot a sheriff, or that Edgar Allan Poe buried a man beneath his floorboards as depicted in his short story, The Telltale Heart, simply because of their respective artistic endeavors on those subjects. The defendants in that case, lyrics, should receive no different treatment. In sum, we reject the proposition that probative evidence about a charged offense can be found in an individual's artistic endeavors, absent a strong nexus between the specific details of the artistic composition and the circumstances of the offense for which the evidence is being adduced. And I would take that a step further. That case and these cases that we cited in our brief, including Jordan v. State, Brooks v. State, United States v. Curtin, involve artistic works that the defendant was alleged to have written or participated in some form or fashion. In Carly's case,
You're not crazy, Jeremiah Johnson. Says, I can't remember, was this her lawyer during trial? No, appellate lawyers are very different. There is a whole separate skill set. There are attorneys who are only appellate attorneys. That's all that they do. And these are new attorneys for the appeal. Some attorneys can do both. For example, compare and contrast with Erin Casanelli in the Aaron Spencer case. She's amazing. She's fire. She represents him not only in the lower trial court, but also she argued in front of the Supreme Court of Arkansas. Not every attorney can do that. So he is new. He's an appellate attorney. That's what he does.
the artistic work at issue is a book that she had absolutely nothing to do with writing. She did not write that book. She had absolutely no contribution to the themes that were found in that book. So we would submit that the propositions cited in by Justice King in Jordan v. State, by the Jersey Court in State v. Skinner, by the Ninth Circuit in United States v. Curtin are even more applicable in the case at bar than they were in those cases. And we would argue that the court erred in allowing the state to introduce that testimony.
Thank you, Mr. Murphy.
If there are no other questions by the justices, thank you, Your Honors.
Ms. Hartman, Mr. Murphy did not mention the crime and punishment argument during his initial presentation. Out of a sense of fairness, if you'd like an opportunity to respond to that, the court will give you a couple of minutes.
Thank you, Your Honor. May it please the court. So the majority of Gregg's argument for crime and punishment is essentially relevance, and that any relevance it did have was more prejudicial than probative. But that's not the standard. The standard is under 403, whether the probative value is substantially outweighed by the risk of unfair prejudice.
Well, Counselor, first you do have to answer the relevancy question.
Yes, Your Honor.
So there's no evidence that Ms. Gregg read that book, correct?
I would disagree with that, Your Honor.
She said she told the counselor she wanted to read the book.
And then she told her that she completed the reading.
Oh, she did say that. I'm
Yes.
sorry. Where is that in the record?
Yeah, where is that in the record, ma'am?
Exactly down.
Counselor. Don't get caught lying to the Supreme Court.
I don't have that citation on my outline, but it is in our brief. I argue that point in the brief. So I know that I cited it there. And essentially, Rebecca Kirk and Gregg discussed those 3 books before spring break, and then they went on spring break, and then the appointment right after spring break, Gregg told Rebecca Kirk that she had completed the reading. So I think from that, it's a fair inference that she read the book.
So, I'm sure you're correct. I'm sure that's in there. So assuming that it is, I still ask the question, what disputed fact in this case does that her reading of the report that she read that book make more or less likely to be true?
I think because the defense put on an insanity defense and they called Dr. Clark to the stand to testify that Gregg was criminally insane under Monotone. He testified that he relied on Rebecca Kirk's treatment notes, and then the state called Rebecca Kirk to rebut Gregg's insanity defense and rebut Clark's testimony about her Monotone insanity. So it's our contention that that's relevant. Her state of mind, the materials she was ingesting, the discussions she was having with her therapist, even about these difficult and complicated classic books, bore on Rebecca Kirk's testimony about her treatment of Carly Gregg, even just 24 hours before Gregg went and murdered her mom. So I think that Rebecca Kirk's treatment notes, including that reference, are relevant to the state's rebuttal of her insanity defense. And Your Honors, even if this court is inclined to hold that Rebecca Kirk should not have been permitted to testify about the summary of crime and punishment, I think this is a classic example of harmless error, because Gregg was not convicted because Rebecca Kirk summarized crime and punishment on the stand. She was convicted because the state...
Right, and Alex Murdaugh was not convicted because Becky Hill tampered with the jury. Guess what? It doesn't matter. Every defendant is entitled to a new trial. And if Alex Murdaugh can get a new trial in the Low Country, I submit to you that at the very least, Carly Gregg should be sent back for a proper Miller hearing and a proper resentencing. If not a new trial, because the defense is arguing for both, either a new trial or a resentencing and a proper Miller hearing pursuant to her constitutional rights as a 14-year-old child. And yes, a 14-year-old is a child, despite her horrific act of murdering her mother. 2 things can be true. You can believe that Carly Gregg horrifically, in cold blood, murdered her mother, and you can also have empathy for Carly Gregg because of the psychiatric conditions that she suffered from, including auditory hallucinations, bipolar disorder, and a cocktail of medications that probably 14-year-olds should not be on. Blame Big Pharma. Nobody knows Carly Gregg the way her family does, and they all stand behind her. So the fact that there's a bunch of strangers out here passing judgment on a person they don't even know, and I'm screaming about the process of a fair trial, our constitutional rights. God forbid this was your child. And it's wild to me that the state is going to get out there and say, well, it doesn't really matter. It doesn't really matter if she got a fair trial or not, because the jury would have found her guilty anyway. The point is, should she be in prison without ever having the possibility, beginning at 15 years old, to ever get out and rehabilitate herself? Or should she be maybe in some sort of mental hospital or mental ward for some period of time and then be sent to prison? And then maybe 30 years from now, when she's 45 years old, have the opportunity of getting out from behind the prison walls? I don't know. I would leave that up to the experts. But the fact that the state of Mississippi seems to think that 14 years old is the proper time to send what had been a very high achieving child, put on a whole bunch of wacky medications with black box warnings, in prison to die, it's just wild to me. It's wild. Let me just back her up a second. She does remind me of Laura McLaughlin.
And Your Honors, even if this court is inclined to hold that Rebecca Kirk should not have been permitted to testify about the summary of crime and punishment, I think this is a classic example of harmless error, because Gregg was not convicted because Rebecca Kirk summarized crime and punishment on the stand. She was convicted because the state presented extensive and overwhelming evidence that she was sane at the time when she murdered her mom, and that she committed the murder with deliberate design. Just a few examples. She appreciated where the security cameras were in the kitchen. She hid the gun behind her back when she was in view of the security cameras so that the camera wouldn't see it. She covered her mom's face with a towel after she shot her point blank in the face 3 times. She called multiple friends on the phone and said things like, I messed up, don't call the police, things that would indicate that she knew what she had done was wrong. She even took her mom's cell phone off the counter right after she murdered her, put in the correct passcode, and then went in the phone, found Heath's contact information, and texted him and asked when he would be home, acting like Ashley. This and abundance of other examples prove that Gregg murdered her mom with deliberate design, but more importantly, that she understood the difference between right and wrong when she murdered her mom, so she was sane under monotony. So irrespective of the crime and punishment summary, Gregg would have been convicted, and this court should affirm her convictions and sentences.
There's really no way to know that, right? There's really no way to know.
Thank you, Your Honors.
Thank you, counsel. The court appreciates your arguments and will take this matter into advisement and render decision in due course. We stand adjourned.
In due course. That could mean, maybe up to 90 days. There are only 6 of them, right? Looks like 5 men, 1 woman. Wow. Lots to unpack here. I want to go back and watch the sentencing. Thank you to the state of Mississippi judiciary for broadcasting this live so that we had an opportunity to watch it together and see what's going on in Mississippi. One moment. Well, we go back to the papers for a minute because there's a couple things I wanted to read you from the brief, and then we will go to your comments, and then I want to rewatch the sentencing with you for those of you who didn't have the opportunity to see it, and those of you who did and may have forgotten what went on during the sentencing phase of this trial. Here we go. It seemed to me like the judges were leaning, I should say, in favor of the plain meaning of the statute, that life imprisonment is different from life imprisonment without the possibility of parole. And it's not really something that was heavily argued in the briefs. So that's really interesting to me. This is when in the Carly Gregg's attorney's brief regarding Miller and the right to a Miller hearing, even under the Mississippi Rules of Criminal Procedure 26.3, authorizes the court to order a pre-sentence investigation and requires that any report be furnished to the parties at least 48 hours before sentencing. And so therefore their argument is that Rule 26.4 contemplates holding the sentencing hearing only after the parties have had that opportunity to review and address the report. In this case, they went from verdict to sentencing immediately. There was no break. It was like right away, within minutes. And they go on to continue to argue in a case of this magnitude where a juvenile faces a potential parole ineligible life term, the court abused its discretion by declining to order a pre-sentence investigation and by pressing ahead without continuing the proceedings to allow completion and disclosure of a PSI. She did. She looked shell-shocked, Diane, like she had no idea what was happening. I agree. I don't know if she was medicated, and I do not know if she was. So, but moving on, here's what the prosecutor said during closing arguments at the sentencing phase of the trial, and we're going to watch it after this, but I just want to summarize it for you because these are the portions that were argued in the brief. Immediately following the jury's verdict of guilty on counts 1, 2, and 3, so it was murder, attempted murder, and tampering with evidence, the trial court immediately went into the sentencing phase of the trial. The trial court asked the state to call its first witness, although the state declined and simply offered to submit argument. During said, so the state was like, no, we want to go. We want to go right away. We want to go right away. During said argument, the state made several highly improper comments that we submit would require resentencing. Now, again, the jury decided the sentencing in this case. That is a weird thing that we do not often see. Usually the judge imposes the sentence, and usually sentencing, as we all know, is held on a different day. Sometimes it's a month away. We just recently watched the Corey Richins sentencing, and it was all day. The sentencing was all day. Many, many witnesses were called on both sides to read victim impact statements. And finally, the judge rendered his sentencing at the very end of the day. So this is wild. Number one, that the jury decides the sentence. And number two, that there was no break in between the verdict and sentencing. She's entitled to a fair trial, period. And so here is the first thing that the state said that the defense argues was improper. The most egregious of the improper comments made by the prosecutor during argument in the sentencing phase was the following. If she's given the possibility of parole, no one in this room knows how long she will stay there. We cannot guarantee she will stay there for 1 year or 10 years. We have no control over that. That's wild to me. And I remember at the time, I think my head popped off and it was on the ferry to Connecticut. Not only was this statement by the prosecutor patently false, and the prosecutor knew it was false, but Mississippi has consistently disapproved of argument which discusses the potential punishment of a defendant. And here's the thing. If this was in front of the judge and they were arguing this to the judge because the judge was going to impose the sentence, that's one thing, because the judge knows a lot more than 12 lay people sitting on a jury. But this was the argument to the jury who was deciding the sentencing. Footnote 13 reads, at the out-of-presence jury instruction conference, the court and counsel discussed the real-world effect of parole eligibility. No one suggested Carly could be released in as little as a year. Yet, in summation, the prosecutor warned that if Carly were parole eligible, quote, we cannot guarantee that she will stay there 1 year or 10 years. Injecting a specter she knew or should have known did not exist to inflame rather than inform the jury. The next thing that the defense argues was inflammatory and fear-mongering was the prosecutor said in summation to the jury on sentencing, if she were paroled, nothing would stop her from walking into a school, a shopping mall, a grocery store, the movie theaters. They go on to say, this is an appeal to fear and community alarm and is highly inflammatory, highly prejudicial, and reasonably calculated to unduly influence the jury. And then again, they're arguing that the prosecution misstated the governing sentencing law for juveniles. The following statement was improper and clearly a misstatement of law in the context of the sentencing phase of the trial. Quote, in the eyes of the law, Carly Gregg is an adult. They go on to argue for Miller's sentencing, the law is the opposite. Children are constitutionally different from adults for purposes of sentencing. And youth/its hallmarks must be given the meaningful weight before LWOP can be imposed. And that is under Miller versus Alabama. It's been the law of the land since 2012. Telling the jury she's an adult risks misleading them about the Miller framework and is further evidence that the entire sentencing phase of this trial was fatally flawed. Just one part of the brief that I wanted to read to you. Now, another part is on page 49, which is when they were talking about the judge not agreeing to an adjournment. And that falls under part 2. Carly was deprived of a fair trial. The trial court committed reversible error by prospectively denying any requests for continuance without evaluating the circumstances that might arise during the proceedings. How many times do we see trials kicked and kicked and kicked and kicked? One that keeps coming to my mind is Courtney Clenny. Courtney Clenny, the OnlyFans model who killed her boyfriend, allegedly. Again, law and disorder, you keep putting these wild comments in the chat. And so I just want to ask you if you watched the trial, because once again, your comments have been so wild today that they're a little out of character and I'm getting concerned. If this went to trial in 6 months, we have possibly an ineffective counsel issue. Let me read to you what the judge did in this case. Let me know if you watched this trial. Methinks no. They go on to say, this was one of the first and most telling abuses of discretion, and it colored everything that followed. At the very first pretrial hearing on June 4th, 2024, during the court's initial exposure to the case, the court noted the September 16th, 2024 trial date and warned that, quote, this court does not continue cases. The colloquy continued, quote, I appreciate Mr. Smiley's position, but I'm just going to be frank. Y'all have heard me say it today. It's not y'all's name that gets run in the newspaper if something happens. It's mine. This case is set for trial in September. I see no reason why this case can't be tried in September. The court then reiterated, I want to make this clear. Y'all have heard me say this multiple times today. This court does not continue cases. So if you need that order, you need to go on ahead and apply for it immediately. We respectfully submit that this categorical advanced refusal to continue, back to one. We respectfully submit that this categorical advanced refusal to consider a continuance was an abdication, not an exercise of discretion. It framed every subsequent ruling, prioritized the calendar over case-specific needs, and set the stage for the errors that followed. The U.S. Supreme Court has cautioned against quote, myopic insistence upon expeditiousness in the face of a justifiable request for delay. And that judge made it absolutely clear that he was not going to entertain any requests for any adjournments. The scheduling posture was not just background, it drove substance. To preserve the September trial date, the court moved from a blanket no continuances stance to coercive pretrial orders that short-circuited the rules. Without the predicates required by the Mississippi laws, the court compelled psychiatric examinations and broad disclosure of defense-held medical records, conferring a tactical advantage on the state and forcing premature exposure of defense strategy. And then they go on to talk about the psychiatric evaluations, which this court did not seem to focus on. They seemed to focus on the plain language of the statute and the plain language of the sentencing order, saying that they think that she should be entitled to parole, and they may just rule that way instead of sending it back. Again, law and disorder. This is another comment of yours that not to call you out, but if you're going to keep putting comments in the chat, you have to understand that I have every right to pull them up. Nobody is stepping on her constitutional rights, Law and Disorder 101 says. She literally took a life in cold blood. My big issue is that you cannot get a jury of 14-year-old peers. What? You have to be 18 to serve on a jury. That's the way it works. I don't think that when they talk about a jury of peers, they talk about a jury who is 14 years old. So I have no idea what some of these comments are about, and this person, Laura, Scott, you already took care of it. But watching this chat is why I prefer Emily Baker's chat. No name calling. Good. Go there. Is she covering this? What a wild thing to say. I don't see anybody name calling, and I have mods who are on top of it. Wild. Amanda says, I love the cupcakes. I love you too, Amanda. Thanks for being here for 15 months. Birdwatcher said, very easy for people to judge others until it happens to you or yours. She's a child that needs help and grace. And Joni said this earlier. If Alec Murdaugh can be afforded a new trial because of Courthouse Becky, I mean, this girl needs her case revisited. Audrey, pointing out the obvious. There's such a lack of empathy. Having empathy for someone doesn't mean you have sympathy for them. Laura is a child psychologist. She says, Carly is very obviously ill. This could send her on a spiral. Then what? Thank you for your 5, Laura. And for your service to children everywhere. Law Junkie says, throwing a child away is repulsive. It's so sad. A child, not a psychopath, never ever diagnosed as such. No, not as a psychopath. She was diagnosed, I think, at one point with bipolar. And she had been having auditory hallucinations, I think, since she was something like 5 years old. Many of you don't know about all the meds she was prescribed and changed doses. Right. And Justice for Carly is here saying she has never read Crime and Punishment. She's never said it. She has never read it. I'm sorry, read it. Let's go back, all the way back to the day of the sentencing. And this was on September 20th of 2024. And of course, Law and Crime, Court TV, in true Court TV fashion, had a name for this trial. And their name for this trial was the Deadly Daughter Murder Trial. Now Court TV and Law and Crime are one. And despite the fact that they are one company under one umbrella, they still are choosing to broadcast the same trials. And this was right after Carly had been found guilty. I'm going to go back a little tiny bit to hear the verdict. And so the verdict is in. This could be triggering for some of you who did watch the trial originally, and some of you are saying, I've never stopped thinking about Carly since this day. After less than 2 hours, the jury came back with its verdict. And you can see on the right side of the courtroom, Carly's family members. I don't know if they're there yet. And this is when the verdict was in. So this is the defense attorney, Catherine Newman, on the left. I'm sorry, not defense attorney. She's the attorney for the state. And on the right, hold on. Let me just see if we can get, I think he's the other prosecutor, right? It was a long time ago. September. Full moon is on Sunday. No excuse on why the chat is so erratic. Thank you, Ryla. No idea. No idea. It's weird. There's a lot of people in here today that I think don't normally come in here. Kat says your chat is amazing and you manage it great. You're only one person. I wish people wouldn't compare creators and our law. It's fine with me. It's fine with me. Also, here's another. I love Emily Baker. I've been watching Emily Baker since before I was even a YouTuber, a law tuber myself. I only started my channel in the summer of 2023. Emily Baker has an Instagram. I follow her on Instagram. I love everything that she does, and I love her opinions, and we all have different opinions. If you ask 5 attorneys for 5 opinions, you will get 5 different opinions. Emily Baker has an Instagram, and on her Instagram, she's been posting her son's graduation. She too has a child graduating high school. And every time she's posting it, I cry myself. I watch her and I cry because it never gets easier, no matter how many kids you have. Watching your kids graduate high school and go off to college is like, it makes me want to cry right now. But she's posting pictures of her son on her Instagram. And I'm thinking to myself, does nobody go after her? And I guess they don't. Because I can't do that. I cannot post pictures of my kids and their accomplishments on social media because there are so many crazy people out there who are out to get me, who I believe will try and go for my kids. And so Emily Baker has a lot of freedoms that I do not have because I chose to speak out early and loudly on the Karen Reed case. And so I'm so happy for her, and her son graduated from high school and he's moved into a dorm and he plays in this traveling marching band and it's amazing. And she freely posts pictures of her children, as do people like Mark Bettero. I cannot do that. I wish I could. I wish I could share those things with you, but I cannot. I can't because of the crazy people on the internet. All right, let's go back now. Bridget Todd is at the defense table with her co-counsel. And it's a shame. So to come in here and to compare us, I don't really care. There's room for everybody. I don't think anybody's in competition with anybody, but it makes me sad. I see Jess Machado posting pictures of her daughter's wedding, and it's great. But I can't do it because people are too crazy. Let's go to when they turn the sound on. And here comes Carly. And I thought the dress they had her in for verdict day was a little too old for her. I think they found it in her mother's closet. It's very sad. Bridget came on the channel, I think twice or 2 or 3 times. And Carly looks completely and totally. And that's Heath Smiley, her stepfather, who stood behind her the whole time. He didn't think that she should go to prison for the rest of her life. Still no volume, but you can just see the deep breaths she's taking. She looks like a baby. And you can see, and she looks over to her stepfather and they say, I love you to each other. And this is heartbreaking. I mean, is there ever going to be sound on this? Hold on.
Unable to affix the.
Okay, hold on. Oh, there we go.
Sides agreeing to rely. All right, ladies and gentlemen of the jury, with both sides agreeing to rely on the testimony from the guilt phase, the court will further with both sides agreeing to rely.
I skipped ahead too far. Hold, please. Do, 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 do.
Now in session, the Honorable Billy Hartman presiding.
All right, please be seated.
Okay, Dexter Saves from the Commonwealth says, when your child disassociates, when they want to take their own life, when they are in pain for a silent illness, you can't fathom what it is like. A lot of people on here with perfect children. Oh, you're going to make me cry. That's a very, very sad statement and an excellent comment, and thank you for that. Okay, here we go. Music to My Soul says, the law nerds would never go after Travis. That's Emily Baker's son. And we would speak out against anyone who did, but I understand why Mel feels like she can't post her family too. No way. No, are you kidding me? Do you wade on the cesspool of Twitter? Do you know what goes on over there? It's wild. Here we go.
All right. The court's been informed that the jury's reached a verdict. I say this in every case. One half of this room, I don't know which half, is going to be upset. Do not add injury to insult.
Okay, hold on. All right, we're done here. So if I'm reading the room, Law and Disorder then goes on to say, any kid between 13 and 25 can do anything, and they just need a hug and a petty visit, never be responsible for murder because it wasn't their fault. Are you kidding? Your failure and your abject inability to even discern any type of nuance in anything is beyond comprehension. It's beyond comprehension. Sayonara. Here we go. Block Island's getting crowded. It's wild.
Do not add injury to insult. If these people did not ask for this job, they didn't want the job, the state and the defense forced them into the job. You will not approve the jury's verdict, and you will not disapprove of the jury's verdict, or you will go to jail.
See, this judge is no joke. Dewey K. Arthur was no joke. Okay? When he said no adjournments, I think he meant it.
It is a 30-day jail sentence for every outburst. I'm going to give anyone who does not believe that they are able to control their emotions the opportunity to leave the courtroom at this time. Would anybody like to leave? All right, Mr. Bailiff, please bring in the jury.
Yes, this is a rewatch from 9/20/24. What? Really? Wow. Virtual juror says they do go after Emily. She posts her oldest because he's agreed to it. When Emily was in LA, she had to have police protection with some of her trials. What? That is Heath Smiley, Carly's stepdad, that she tried to kill, attempted murder.
You sit right there, ma'am. Ma'am, I see you're holding some papers. The jury been able to reach a verdict in any of these counts.
Yes, sir.
All right, if you would, please hand the paper to the bailiff.
If you can come to your screen and you're not driving or you're not on scaffolding or on a ladder, try and come to your screen to watch this.
Ms. Gregg, please rise and come to the podium, along with your attorneys. All right, the verdicts appear to be in proper form. Verdict of the jury is count one. We, the jury, find the defendant, Carly Madison Gregg, guilty of first-degree murder as charged in the indictment. Count two. We, the jury, find the defendant, Carly Madison Gregg, guilty of attempted murder as charged in the indictment. Count three. We, the jury, find the defendant, Carly Madison Gregg, guilty of tampering with evidence as charged in the indictment. Please be seated, Ms. Gregg. Ladies and gentlemen, the jury is custom for the court to poll the jury. I have to do it each time. And for each count, I'm not being rude. The quickest way for me to get through this is just simply point at you and you answer out loud. As to count one, we, the jury, find the defendant, Carly Madison Gregg, guilty of first-degree murder as charged in the indictment. Beginning on the first row, ma'am, is that your verdict? Sir, is that your verdict?
Yes, sir.
Ma'am, is that your verdict? Sir, is that your verdict? Ma'am, is that your verdict? You got to answer out loud, ma'am. I'm sorry.
Carly has no idea what's going on. I think she's disassociating in this moment too. Bridget Todd looks gutted. Here we go.
On the back row, sir, is that your verdict? Ma'am, is that your verdict? Ma'am, is that your verdict? Sir, is that your verdict? Ma'am, is that your verdict? Ma'am, is that your verdict? Ma'am, is that your verdict? That verdict is proper and unanimous. As to count 2, we, the jury, find the defendant, Carly Madison Gregg, guilty of attempted murder as charged in the indictment.
Right there in the gallery, you see her grandma, who is her mother's mother. Wait, I'll stop it when I get to it again. Even if I don't agree necessarily with the verdict, my verdict would have been not guilty by reason of insanity. Maybe it wasn't proven beyond a reasonable doubt. I don't agree with the sentencing. I don't agree with the sentencing. That's where I have a disconnect here.
You got to answer out loud, ma'am. I'm sorry.
Yes.
On the back row, sir, is that your verdict? Ma'am, is that your verdict? Ma'am, is that your verdict? Sir, is that your verdict? Ma'am, is that your verdict? Ma'am, is that your verdict? Ma'am, is that your verdict? That verdict is proper and unanimous. As to count 2, we, the jury, find the defendant, Carly Madison Gregg,
There's her grandma, Ashley's mother.
guilty of attempted murder as charged in the indictment. Beginning on the first row, ma'am, is that your verdict?
Yes, sir.
Sir, is that your verdict?
Yes, sir.
Ma'am, is that your verdict? Sir, is that your verdict?
Yes.
Ma'am, is that your verdict?
Yes.
On the back row, sir, is that your verdict?
Yes, sir.
Ma'am, is that your verdict? Ma'am, is that your verdict? Sir, is that your verdict? Ma'am, is that your verdict? Ma'am, is that your verdict? Ma'am, is that your verdict? Count 3, we, the jury, find the defendant, Carly Madison Gregg, guilty of tampering with evidence as charged in the indictment. Beginning on the first row, ma'am, is that your verdict?
Yes,
Sir, is that your verdict?
Yes, sir.
Ma'am, is that your verdict? Sir, is that your verdict?
Yes, sir.
Ma'am, is that your verdict?
Yes, sir.
On the back row, sir, is that your verdict? Ma'am, is that your verdict? Ma'am, is that your verdict? Sir, is that your verdict? Ma'am, is that your verdict? Ma'am, is that your verdict?
Sorry.
Ma'am, is that your verdict? All right.
I'm sorry, that woman was Heath's mother, but Ashley's parents were there too as well. They just didn't show them. Thanks, Justice, for Carly.
3 verdicts appear to be unanimous. The court will enroll the verdict. All right. All right, ladies and gentlemen, with you having returned a verdict of guilty in count 1 and count 2 of the indictment, we'll now proceed to the sentencing phase of the trial. The state of Mississippi may call its first witness.
Your Honor, the state has no witnesses. We would just ask that the court adopt the previous testimony that the jurors have heard.
When have we ever seen this before? In the trial of a child, of a minor. Yeah, she's being tried as an adult, but under the Constitution, she's entitled to a Miller hearing, right? Can we agree on that? Can anyone agree on that? Okay, now we're going to go straight to sentencing. Boom, boom, boom. No pre-sentencing investigation, no constitutionally protected Miller hearing. We're just going to go straight to sentencing. And the state's like, we don't even want to call any witnesses. We know which way this is going, Judge. Go on with your bad self. We'll just argue. Here you go.
State of Mississippi may call its first witness.
Your Honor, the state has no witnesses. We would just ask that the court adopt the previous testimony that the jurors have heard, with the exception of we seek to introduce one photograph.
All right. State wishes to move to adopt and incorporate by reference the record of the guilt phase. Is that correct?
That's correct.
Show your piece of evidence to the other side.
I mean, he threatened jail time for anybody who even reacted in any way, shape, or form to the verdict. This whole thing is wild.
Any objection?
Yes, Your Honor.
Y'all approach.
None of the arguments were done, so that we could hear them. It was done sidebar, so we don't even know what Bridget was arguing here. And there's Carly. And you'll see the way that the jury is instructed on sentencing, and it's I don't know, it's beyond the pale. And Zoe says, what was the judge's hurry? He acts like he's not paid on salary. Did he have a vacation booked? Maybe. Patty says, When a witness lies, you can assume all their evidence is lies. When a judge does something like this, you have to assume the whole trial was unfair. Lolita says, people don't understand a jury isn't actually your peers. Law Junkie says, her stepfather was there to support her 100%. He was shot too, right? The charge for him was attempted murder. And she got LWOP for that too. There's extensive show notes below the video, Sylvia's daughter, if you're not familiar with the case. I took a lot of time to type them out, and they're not even AI. They are actually drafted by me. Bridget trying to console Carly.
All right, the state has moved to adopt and incorporate by reference the record of the guilt phase of the trial. The court will grant that request. Does the state have any other witnesses it wishes to call?
No, sir, Your Honor.
All right, defense may call any witnesses.
We don't have any witnesses, Your Honor.
All
How
right.
could they? They don't have time to call any witnesses. I think maybe they thought that she was going to get not guilty by reason of insanity. Maybe it would be different. Maybe she would be confined to it. Like they didn't even have to, the family didn't even have time to draft their victim impact statements. Do you see how unfair this is? Does anybody, can anybody in the chat at least see that? Witnesses for sentencing, mitigation, victim impact statements, letting her family get up there and speak, giving Carly the ability to draft something to say. Can we at least agree on that? Wow, this is so insane.
With the defense not calling any witnesses, attorney's approach. Does the defense rest its case in chief as to sentencing? Do you also move to adopt and incorporate by reference the record? All right, y'all approach.
At this point, the defense is like waving the white flag. Like, forget it. We have a better chance on appeal, because if we even try and complain or object or do anything, ask for an adjournment, he's not going to grant it. He already made that very, very clear. Let's just wave the white flag and just go straight to an appeal. And by the way, this was in September of 2024. We are now in May of 2026. So a little more than 18 months after this sentencing, the Mississippi Supreme Court has already just today heard this case, which is wildly fast. So they approach again. They're going to show some shots of Carly. Court TV really like to focus on her. They're at sidebar for a while.
Agreeing to, all right, ladies and gentlemen of the jury, with both sides agreeing to rely on the testimony from the guilt phase, the court will further instruct you at this time. You, the jury, have found the defendant guilty of the crime of first-degree murder in count 1. You must now decide whether to impose either a sentence of life imprisonment in the custody of the Department of Corrections or life imprisonment in the custody of the Department of Corrections with the possibility of parole. The court instructs the jury that you should consider the following factors in making your decision.
So here's how he's instructing them. Life or life with the possibility of parole. He's giving them both options. Okay? Here we go. We don't know if they objected. We don't know if they had objected at sidebar because we didn't hear it, right?
1, the defendant's chronological age.
Here's the things that you should consider. He's saying you should consider the following, whether you decide life or life without parole. Okay? To me, the plain language of these jury instructions is either life, meaning life without parole, or life with parole. There's no other options. There's no 25 to life. There's no 50 to life. There's no 10 to life. That is it. Life or life with the possibility of parole. She's 14.
Corrections with the possibility of parole. Now decide whether to impose either a sentence of life imprisonment in the custody of the Department of Corrections or life imprisonment in the custody of the Department of Corrections with the possibility of parole. The court instructs the jury that you should consider the following factors in making your decision. 1, the defendant's chronological age. 2, the defendant's family, home, and environment. 3, the circumstances of the homicide offense. 4, the defendant's incompetencies associated with youth. And 5, the defendant's possibility of rehabilitation. The court instructs the jury that when all 12 of you reach and agree upon the defendant's sentence for first-degree murder, you shall return the sentence in one of the following forms. If you agree to sentence the defendant to life imprisonment in the custody of the Department of Corrections, your verdict will be as follows. Quote, count one. Quote, as to count one, we the jury sentence the defendant Carly Madison Gregg to life imprisonment. Close quotes. If you agree to sentence the defendant to life imprisonment in the custody of the Department of Corrections with the possibility of parole, your verdict will read as follows. Quote, as to count one, we the jury sentence the defendant Carly Madison Gregg to life imprisonment with the possibility of parole. Close quote. If you cannot agree to the sentence for the defendant as to first-degree murder, your verdict will be as follows. Quote, as to count one, we the jury are unable to affix the punishment. Close quote. You, the jury, have found the defendant guilty of the crime of attempted murder in count two. You must now decide whether to impose either a sentence of life imprisonment in the custody of the Department of Corrections or life imprisonment in the custody of the Department of Corrections with the possibility of parole. The court instructs the jury that you should consider the following factors in making your decision. 1, the defendant's chronological age. 2, the defendant's family and home environment. 3, the circumstances of the homicide offense. 4, the defendant's incompetencies associated with youth. And 5, the defendant's possibility of rehabilitation.
Those are all of the Miller hearing requirements. And this is the Miller hearing, essentially. This is 3 minutes with neither side presenting any evidence about any of the things that the judge is telling them that they should now consider. Here you go. Here's what the jury should now consider without any expert testimony or anything. It's wild.
Instructs the jury that you should consider the following factors in making your decision. 1, the defendant's chronological age.
So you should consider her age. He's just telling the jury to do this. These are typically things in most other states that the judge takes into consideration before imposing sentence. This is crazy.
2, the defendant's family and home environment. 3, the circumstances of the homicide offense. 4, the defendant's incompetencies associated with youth. And 5, the defendant's possibility of rehabilitation. The court instructs the jury that when all 12 of you reach and agree upon the defendant's sentence for attempted murder, you shall return the sentence in one of the following forms. If you agree to sentence the defendant to life imprisonment in the custody of the Department of Corrections, quote, as to count 2, we the jury sentence the defendant Carly Madison Gregg to life imprisonment, close quote. If you agree to sentence the defendant to life imprisonment in the custody of the Department of Corrections with the possibility of parole, your verdict will read as follows, quote, as to count 2, we the jury sentence the defendant Carly Madison Gregg to life imprisonment with the possibility of parole, close quote. If you cannot agree to the sentence for the defendant as to attempted murder, your verdict will read as follows, quote, as to count 2, we the jury are unable to affix the punishment, close quotes. All right. First closing by the state as to sentencing.
This is like a whiplash trial. This is like going from guilty to sentencing, like whiplash. I'm getting whiplash. Desiderata, yes. You popped in at a heartbreaking moment that will last her lifetime. Now listen to the closing argument by the state, which we just went over the portion of the brief, the appellate brief, in which defense made its arguments about what things this prosecutor says that are highly inflammatory, improper, prejudicial, and how they're saying it should be sent back. Not if you don't agree on the fact that it should be sent back for a new trial, at least send it back for a proper Miller hearing and a proper resentencing. Okay, listen to it now. I'm going to trigger warn you in advance because it's wild. And the way that I read it to you from the brief is a lot different than the way that the prosecutor emphasizes. And just listen.
Mr. Bailiff, 7.5 minutes. You wish a 2-minute warning or a 1-minute warning?
1 minute is fine.
1 minute.
7.5 minutes. 7.5 minutes to argue whether or not a 14-year-old at the time of the crime should be sentenced to life without parole or life with parole. That's it. 7.5 minutes each. Ready, set, go. Here's my timer. You want a 1-minute warning or a 2-minute warning? What do you want? You want chicken or steak? What do you want? You want tacos or mac and cheese? What do you want? It's gross.
You may proceed.
Ladies and gentlemen, you've been here for 5 days now. Over 5 days, we've heard about this terrible crime that was committed by Carly Gregg. You have to consider her chronological age. We can't change that. She's 15 years old. In the eyes of the law, we talked about this on Monday, Carly Gregg is an adult. You do get to consider her age, but that's not the only factor you consider when you determine whether or not to send her to prison for life. We'd ask that she be sent to prison for life without the possibility of parole, and let me tell you why. When you consider her family and home environment, ladies and gentlemen, by all accounts, the defendant has told you she had a loving home. She had parents that adored her. She had every opportunity, more opportunities than most kids. She was advanced in school. She had guitar lessons. They took her to equestrian therapy. They took her to counseling. She had the opportunity.
Yeah, they took her to equestrian therapy because she was hearing flipping voices when she was 5. This is Catherine Newman. Welcome to the Catherine Newman Show, everyone. How can you prepare your sentencing argument in the 3 seconds in which you are blindsided and smacked with 3 guilty verdicts? How can you possibly not have a break in between? She had a great home life. Right. State didn't have to ask for LWOP. They already got the win. And they sentenced her to LWOP on an attempted murder charge, which is against the guidelines. This whole thing is a mess. Listen to that again. She had guitar lessons and equine therapy. Here you go. Oh, here comes Turtle Boy's Pond. Did Carly give her mom a 7-minute warning before she unalived her? Oh, aren't you sweet? Aren't you sweet? Oh my God. How did this person survive this long in here? And I think we know who it is now. Hold on a second. We know who that troll is. You guys would flip out if you knew who so many of these trolls were. You would really flip out. People you think are friendly are really, really fooling a lot of people. Here you go.
The defendant has told you she had a loving home. She had parents that adored her. She had every opportunity, more opportunities than most kids. She was advanced in school. She had guitar lessons. They took her to equestrian therapy. They took her to counseling. She had the opportunity to have medication. Nothing was enough for her. She still committed these heinous crimes. Nothing. Her home life was a perfect home life. When we talk about these factors in Miller, that usually comes up when we talk about these defendants that have been grown up on the streets, when their parents weren't present. Now, did Carly have a dad that she didn't love or had problems? Absolutely. But ladies and gentlemen, that is not enough. That is not enough for her to be able to walk the streets. She murdered someone. She attempted to murder her stepdad. Her family life and her dad being on drugs is not enough. The circumstances of the homicide, I don't have to tell you that. Y'all just lived it. You watched it. You saw those awful photographs. You had to watch that terrible video. We listened to Ashley Smiley's last sounds. We heard from Heath Smiley on that 911 call, the desperation. He said, "Help me, help me." Ladies and gentlemen, those crimes were awful. She has shown zero remorse for what she has done. Let's talk about her ability for rehabilitation. The defendant's own expert during the guilt phase of this trial said, she's on this medicine, she's fine. But if you believed that, ladies and gentlemen, you would have believed that she was having some disassociated spell at the time of the crime and that she's continuing to have these disassociated spells. And obviously no one's buying that, right? We don't know why she committed these crimes, but we know she did. And we know that she is a danger to society. If she is given the possibility of parole, no one in this room knows how long she will stay there. We cannot guarantee she will stay there 1 year or 10 years. We have no control over that.
Do you think that's inflammatory? Do you think that's fear mongering of the jury? Because that's the argument on appeal, that this was highly improper, totally improper, that this was complete BS, that this was allowed, and that it's fear mongering.
Ladies and gentlemen, we watched one of the most heinous things that I believe most of you will ever see in your life. Please do not let this lady have the possibility of parole.
Lady.
If she were paroled, nothing would stop her from walking into a school. Nothing would stop her from walking into a shopping mall. Nothing would stop her from walking into the grocery stores. Nothing would stop her from being in the movie theaters.
Also, community fear mongering. This lady, she was 14. Yes. Thank you, Jersey to Georgia. This does seem very eerily. Well, no, I was going to talk about Lindsay Clancy and compare her to Mackenzie Shirilla. Maybe we'll do that later if you remind me.
Ladies and gentlemen, she is dangerous. She may look like a little girl. They may have said she's sweet little Carly, but unfortunately, we all know that that's not true. We will ask, and I will ask you again when we stand back before you, that you sentence Ms. Gregg to life in prison without the possibility of parole for both the murder of her mother, Ashley Smiley, and the attempted murder of her stepfather, Heath Smiley. Thank you.
What does she take? 3 minutes out of her 7.5?
Argument says sentencing by the defense.
I don't think Bridget could
How
even.
much of a warning would you like, Mr. Camp?
2 minutes, Your Honor.
2 minutes.
This is Mr. Camp, co-counsel for the defense. He wants his 2-minute warning out of 7.5. And I think at this point, I think we did talk about this when Bridget came on the channel. She couldn't do it. She couldn't do it. Like, she was so choked up, she couldn't even do it. Like, she had so much empathy for Carly. She's really a special attorney and a special person. Bridget Todd is. Here's the defense argument on
15 minutes
sentencing.
total.
Thank you, Your Honor.
Yes, sir.
I'm gonna have to tell you, this is probably,
Did he just say, I'm going to give you 15? I'm going to give you 15 minutes total. I'm going to give you 15 minutes total because I don't want, to be overturned on appeal. So I'm going to give you double the time.
2 minutes, Your Honor.
2 minutes. 15 minutes total.
Thank you, Your Honor.
Yes, sir.
I'm gonna have to tell you, this is probably the most difficult thing I've ever had to do. I respect your,
And it was, and you can see how different this was for him. Lacey says, I'm sorry, but I would be scared of her going to public places though. She's not going anywhere. She's not going anywhere. I mean, that just goes to show that you were subjected to what she just said as community fear mongering. It is completely improper for her to say she could be out in a year. No, that's not true. She lied. She lied.
your jurors, and I respect your, I respect your jurors, and I respect your verdict, and I totally understand that. And now I'm in front of you. Gregg, when this happened, was 14. She's 15 now. Her family's sitting on the front row. Her grandparents, which are Ashley's mother and father, have been supportive during this whole process. Heath Smiley, who's the victim in this case, he has been supportive. This is a family that's been torn apart because of this. This is extremely, extremely difficult on all them. I know the state is up here saying that she's this heinous individual. And you've heard a lot of testimony that that's not who Carly is. You heard the counselors, Ms. Kirk. She couldn't believe it happened. Nobody knows why it happened. You have the opportunity to not make this worse on the family. You have three options. You can do life without parole, you can do life with parole, or you can let the judge make the determination. In this case, we would ask you, let the judge make the determination. We don't want you to give her a sentence for life in prison. Life in prison is life in prison. That's it. 14-year-old. She can come out of this at some point. Anywhere you're hearing, she can walk out of here and first of all, we don't know. And usually it's a lot longer than that. I mean, a lot longer. So I don't want you to, go back in that room and think, oh, if you come back and say she gets parole, it's not a short sentence at all. We would ask you to allow the judge to make the sentence, because the judge understands. I'm not saying y'all don't. I mean, you don't have the ability, so don't get me wrong.
You're giving them way too much credit, Mr. Camp. Jurors don't even understand beyond a reasonable doubt. Some jurors don't even understand innocent until if and when proven guilty. These jurors have no idea what life means and what life without parole means and what the difference between the two is. And the judge is far more qualified to make this decision, in my opinion, than a layperson jury. Many of you might be very more highly educated jurors because you watch a lot of trials. These are 12 people from the community who don't watch a lot of trials, probably, because if they did watch a lot of trials, they probably would have stricken them from the jury. It's insane. They wanted to get out there for Labor Day week. Well, no, this was September 20th, so it was after Labor Day weekend. Labor Day is usually in the beginning of September, yeah. Somebody asked if you think it would have been a different outcome had Bridget done it. I don't know. Wrong
on that. The ability, so don't get me wrong on that. But he knows, and the court knows, what we're actually looking at with times. And so please, in this situation, please let the judge make the sentence in this case.
That was it. He's just asking them to please let the judge do it. Chrissy said,
Closing on behalf of the state.
Chrissy said, I never felt unsafe living next to her at the very time this happened. So did you live next door or near Carly Gregg? So there absolutely was no warning, right? Did she snap? Was it a psychotic break? This is a case of a medication-induced psychotic episode. Thank you, Christy, for chiming in from Carly Gregg's neighborhood.
Final closing on behalf of the state. Is that what happened?
Ladies and gentlemen, Mr. Camp is right. We may never know the reason why Carly killed her mom and attempted to kill her stepdad. And for me, that's even scarier than knowing why. Because if we don't know why, what's to say it won't happen again?
Carly's face.
We don't know. It is terrible for the family. The family has my sympathies, absolutely. I cannot imagine what any of them have gone through. We talked in voir dire about how sometimes the victims cooperate with the prosecutor and the prosecution, and sometimes they don't. We don't always know why. But I know this. My office represents the citizens of Rankin County, and my office is asking you to please sentence Ms. Gregg to life in prison without the possibility of parole. Thank you.
Ladies and gentlemen of the jury, you've received you've heard the arguments. I'm going to ask you, I'll send you back the instructions. I'm going to ask that you retire to begin your deliberations. Everyone remain seated while the jury exits.
Look, if you can look at your screen, look at Bridget Todd just trying to hug Carly like. Joe Mar says, my heart's aching watching this. It's all outrageous. It went down like this in 1 hour without hearing from anyone in her defense.
Mr. Bailiff, they still have the verdicts, the evidence.
Yes, sir.
All right, if you would take those to them. All right, we'll be in recess till such time as the jury reaches its verdict regarding sentencing.
Carly has no idea what's happening. Melanie Schuyler pointing out that a 14-year-old child will act differently when she's a mature adult with medication. Carly going back with the bailiff. Back into custody. And let's say this was at 4:42:09. And so for the penalty phase, since this was on real time with Court TV, they were out for a little, let's say what did I say this was? 4:42. They come back at 5:39, less than 1 hour. Less than 1 hour. Jury comes back. Here's Carly walking in. I'll just turn off this for 1 second because of the music. I might get stricken. Ain't no reason to get stricken after all this. Less than 1 hour, the jury comes back with their verdict on sentencing. Here's Carly walking back to the defense bench. And the jury did decide to do the sentencing instead of letting the judge decide, as I recall, right? Yeah. And there is Heath and his mother. And to Heath's left, wait, so which one is Ashley's mom? The one sitting to the right of the screen of Heath or to the left of the side of Heath? Because Ashley's parents too were in the courtroom, and Carly actually laughed for a second. She has no idea what's happening here, in my opinion. And at least her grandma or her step grandma and her stepdad are showing her some love.
I've been told that the jury's reached a verdict as to sentencing.
Max Bang telling us the
Jury's
man who
verdict is,
unalived
as I said before,
who took my niece's life in front of her 14-month-old child, then dumped her in a well, only served 10 years. Tell me how this case is a fair sentencing. That's why it's so wild, the way that this varies from state to state. Paula says, once you see disassociation, you will never forget it. Let me know. Tell us your opinion on this case, Paula. It's bringing back a lot of memories from September of 2024. And once again, he's going to admonish the gallery. And it was pretty empty in that courtroom. We just saw a shot of it. Here we go. I am very sorry, Max, too.
As I said before, they didn't ask for the job, and we will not praise their verdict, and we will not condemn their verdict. Any outburst, positive, negative, whatsoever, will be direct contempt of court, and you will serve 30 days in jail for each outburst. If you cannot control your emotions, you should leave the courtroom at this time.
30 days in jail for each outburst.
Mr. Bailiff, please bring in the jury.
Here we go. My brief of the brief. Hello, Michelle. So the verdict did say that they would do the sentencing, yes. Thank you, friendly farm girl. Oh, good citizen Weymouth says, breaking news, little G, my granddaughter is finally taking her first real steps. Oh, dear Lord, help me. Oh, now the chasing begins. Thank you for your 10 and congratulations. Little G is our model for our merch, and she's adorable, adorable. Reaper's mom says, but wouldn't you file a motion anyway for a continuance, even if the judge said that? They didn't request that one, did they?
The jury been able to reach a unanimous verdict.
Are you talking about pretrial? I don't remember that in the pretrial filings, but hindsight is always 20/20, right? Thanks, Reaper's mom. I don't remember from the pretrial docket, but that's a great question. Thanks for your 10. He says, I see you're holding your papers that you've been able to reach a unanimous verdict.
Madam, I see you're holding paper. The jury been able to reach a unanimous verdict.
Yes, sir.
Please hand that to the bank. All right, the verdict appears to be in proper form. Mr. Gregg, if you and your attorneys would come to the podium.
Here we go. They go to the podium again.
The verdicts read as follows. As to count 1, we, the jury, sentence the defendant, Carly Mass and Gregg, to life imprisonment. As to count 2, we...
Clear, right? They had three choices. Life imprisonment with the possibility of parole, or we can't decide, let the judge decide. Those are the three choices. They came back with life imprisonment, which by process of elimination is not with the possibility of parole. LWOP.
The jury sentenced the defendant, Carly Mass and Gregg, to life imprisonment. Please be seated. Ladies and gentlemen.
So on counts 1 and 2, the murder and the attempted murder, life imprisonment. They had 3 choices. Let's hear it again and watch Carly's reaction, because she seriously has no idea what's going on.
The verdicts read as follows. As to count 1, we, the jury, sentence the defendant, Carly Mass and Gregg, to life imprisonment. As to count 2, we, the jury, sentence the defendant, Carly Mass and Gregg, to life imprisonment. Please be seated. Ladies and gentlemen, just as I did with the verdicts of guilt, not trying to be rude. It's the quickest way we can get it done. As to count 1, we, the jury, sentence the defendant, Carly Mass and Gregg, to life imprisonment. Ma'am, is that your verdict?
Yes, sir.
Ma'am, is that your verdict? Sir, is that your verdict?
Just like that.
Ma'am, is that your verdict? Ma'am, is that your verdict? On the back row, sir, is that your verdict?
Yes, sir.
Sir, is that your verdict?
Yes, sir.
Ma'am, is that your verdict?
Yes, sir.
Ma'am, is that your verdict? Sir, is that your verdict?
Yes, sir.
Ma'am, is that your verdict? Ma'am, is that your verdict?
Yes, sir.
As to count 2, we, the jury, sentence the defendant, Carly Mass and Gregg, to life imprisonment. On the front row, ma'am, is that your verdict?
Yes, sir.
Ma'am, is that your verdict? Sir, is that your verdict?
Yes, sir.
Ma'am, is that your verdict? Ma'am, is that your verdict? On the back row, ma'am, is that your verdict?
Yes, sir.
Ma'am, is that your verdict? Sir, is that your verdict? Ma'am, is that your verdict? Ma'am, is that your verdict?
Yes, sir.
Sir, is that your verdict? And sir, is that your verdict?
Yes, sir.
Verdict appears to be in proper form. Ladies and gentlemen, the jury, please exit. I will be there in just a moment to release you, okay? Everyone remain seated while the jury exits.
Heath Smiley has his eyes closed. I think to his left, I think that is Ashley's mom. To his right, that is Heath's mom. I wonder if the jurors have any regrets at their decision as well. Thank you, our N2 moms. Natalie says, wait, they can really throw you in jail for 30 days automatically for an outburst? Well, that's his rules. His courtroom, his rules. Ashley's parents are right behind the defense attorney, says KVD.
Ms. Gregg, please come to the podium.
Shannon Pettigrew says, this is also my town, a couple miles away, and same schools as our kiddo. Swiper, no swiping. That hasn't happened in a long time. Well, it just happened the other day. I lie. Sometimes it happens because StreamYard sucks and there are no other alternatives. And if I'm on my mouse pad trying to flip from one screen to the other, to drag something over here, to put something over there, to close tabs, to open tabs, this is a whole production back here. You have no idea. It swipes me out of the stream. But don't worry, because I stopped the video at exactly the same time. So we didn't miss a thing. Carly got sent back to her seat.
Your sentences will be as follows. As to count 1, the jury having fixed the verdict at life imprisonment, this court will sentence you to life imprisonment. As to count 2, you'll be sentenced to life imprisonment. As to count 3, you'll be sentenced to 10 years to serve.
So the jury didn't get to decide the sentence on the tampering with evidence, but the judges just throws in another 10 years. Life imprisonment, life imprisonment. I mean, clearly they had 2 options, life imprisonment or life with parole. So the one that they picked is the one without parole. Is that constitutional? Number 1, to sentence a juvenile to life in prison without parole for an attempted murder charge. That's the argument. And number 2, under the Constitution of as such the United States of as such America, was she entitled to a Miller hearing because she's a juvenile?
You'll be required to pay court cost fees and assessments in the amount of $431.50. Ms. Gregg, regarding any appeal of your judgment of conviction and order of sentence and in accordance with Wright versus State 577, Southern 2nd 387, the court wants to inform you that pursuant to Rule 4E of the Mississippi Rules of Appellate Procedure, the notice of appeal required by Rule 3 of such rule shall be filed with the circuit clerk within 30 days after the date of the denial of any motion for a new trial or the date of imposition of sentence, whichever is later. Pursuant to Rule 4E, if you make a timely motion under the Mississippi Rules of Criminal Procedure for a judgment of acquittal notwithstanding the verdict of the jury or for a new trial under Rule 25.1, the time for appeal shall run from the entry of the order denying such motion. Finally, Rule 25.1 subsection C provides that a motion for a new trial must be made within 10 days of entry of the judgment, which includes both adjudication of guilt and sentence. Should you make a decision on the record to appeal, that decision will stand unless a written statement to the contrary signed by you and your attorney is filed with the court. Should you make a decision to waive appeal, that decision will stand unless you give written notice to the court and your attorney prior to expiration of the time in which you perfect an appeal. Should no decision to appeal be made by you, your failure to express a desire to appeal shall be considered a waiver of your right to appeal, and that waiver will stand unless you give written notice to the court and to your attorney prior to expiration of the time in which to perfect an appeal. Have you made a decision to appeal your conviction and sentence? All right. Court will be in recess.
Your Honor, I need clarification. I apologize. On the
Sentences will run concurrently.
Concurrently. Life without parole, life without parole at the same time. Still the same net effect, right? Plus 10 years, all at the same time concurrently. There's Heath's face. And pretty much an empty courtroom. Not a lot of people there. For a case of this magnitude, a lot of empty pews. It's heartbreaking. I urge you to go back and watch the trial if you haven't watched it. I will link my trial playlist below, but if you just look through my playlists, you will find the one for Mississippi versus Gregg. And it's giving me flashbacks of having watched this with you. And just in my opinion, one of the injustices that we've seen together. And now we are getting a little more glimpse into the law and exactly why this may go back for, if not a new trial, a resentencing. Let me know your thoughts, questions, comments, concerns, not only here in the chat, but also in the comments after this video. If you hype the stream, that's very good for the channel. If you like the stream, it's very good for the channel. If you leave comments, if you hit the like button, all of that stuff is really good for the channel, and it helps the algorithm because YouTube is trying to push you away from long form content like this and push you toward shorts and AI type videos. And you know how I feel about AI. It's destroying the planet. And I hate it. I have a lot of concerns. Was she evaluated for competency to stand trial? Yes. But, and this is part of the brief, I don't want to misspeak, so I have to go back and look at the brief again. But I believe that it was one evaluation for the insanity defense and for the competency to stand trial. And if someone in the chat knows better than I do. I just don't want to answer your question inappropriately, Megan, but I know you and you know me and you know how to email me and I can email you the briefs. But my understanding was that it was one, because this was so rushed, it was one evaluation for both. But now I could be conflating that with another case. So I don't want to tell you the wrong thing, but I will email you the briefs if you want to have them. Dancing Queen, where is she now? She's apparently serving time in a juvenile ward. Apparently there is a juvenile ward in the state prison. I forget the exact prison that she's in. But pre-trial, she was held in solitary because my understanding was that the pre-trial facility in which she was being held did not have a juvenile, a portion or wing. And so she was 23 hours a day in solitary. Thank you. Thank you. Before you redirect my viewers to a channel who spews hate about me, I don't know, just think before you hit send. I don't know, just common courtesy, word to the wise is all I'm saying. I think that's what happens. I think a dog mom, she goes to a juvenile facility or at least a juvenile ward until she's 18, and then she gets transferred to the women's prison. Daisy, we were talking about the differences between trial counsel and appellate counsel. Says, I wholeheartedly agree. You have to know your case plus applicable case law, plus anticipate any arguments from the opposition. Yeah, plus anticipate any questions from the judges. The best attorneys out there are appellate attorneys, in my opinion. I don't know if it's the best attorneys. It's definitely a different skill set. In my practice, we would always hire appellate attorneys to go in and argue the appeals because it is a special skill set to draft briefs, to get the briefs printed in the proper way, and to argue in front of an appellate court. Sometimes we would do it. Sometimes we would hire outside counsel. It depends. It is a very specific skill set. And people who are great trial lawyers are not necessarily great appellate lawyers. I happen to think that, again, I'm going to bring her up again, Erin Casanelli, the attorney in Arkansas for Aaron Spencer, can do both, and she can do both really, really well. Coffee. This was a great comment from before. Said, I don't necessarily think it's a good thing to have LWOP for young people, but isn't that a legislation issue? Appeals are for failures within the trial. Yes, the law had been changed in July before she was sentenced. And that is another argument here. You are absolutely right. Judges don't make the law. Sometimes their rulings do make new law, new case law. But it's my understanding that the statute was changed right before Carly's trial. Thank you, Scott McGinnis, for being here for 25 months. Says that my channel is his #1 favorite. In-depth A1. Thank you so much. Justice for Carly is here. And I'm assuming, I don't know if you're related to Carly. If you run the Justice for Carly movement or Facebook page, says prosecution were allowed 3 mental health experts, defense only 1. How is that balanced to the jury? Resisting arrest. Yes, the judge and his pregnant pause. Here's what Zoe, our resident statistician, had to say. And I know that when I pull up anything that Zoe says, she has done 100% of the research and it's 100% correct. She says, per the Sentencing Project, as of 2020, Mississippi had 92 juveniles with life without parole or a virtual life VL sentence. 92. Juveniles make up over 10% of the total population serving LWOP/virtual life sentences in Mississippi. Over 10%. Remember what happened with Jesse Butler in Oklahoma? Oh, well, let me remind you. Jesse Butler, at the age of 17, violently raped 2 girls in his high school. I think they were 16, maybe. And violently raped them. One of them was 30 seconds from death, according to her doctor, because he strangled her so badly. And he also filmed it too. Some of those attacks were in his house, and he was charged with many, many charges. I forget how many, but I think it was over 70 charges, over 70 felony charges of rape and strangulation and filming these things on his phone against at least 2 victims. And he was supposed to go, wait, was 72 charges, or he was supposed to go away for over 72 years? Now I'm conflating maybe. But what had happened was in Oklahoma, because Jesse's dad was part of the OSU football program, and also ran, I think, the football program at the local high school that Jesse attended, as these two girl victims also attended. He got special juvenile offender status, even though he was supposed to go to jail for over 70 years. The judge just gave him a little slap on the wrist, and he has to do 1 year of therapy and community service. And then Jesse Butler in Oklahoma will go free. So make it make sense to me. Make it make sense. And then Zoe also said California, as of 2020, had 2,538 juveniles serving JLWOP, juvenile LWOP / virtual life sentences, making up only 6.6% of the total LWOP and virtual life population in California. Mr. Perfect says Mississippi is definitely a good old boy state. Thanks for hanging out and being here for 9 months. I appreciate you, Mr. Perfect. Baby Doll says, I'm going to speak up. I live in the same county as Carly. I also dealt with a troubled teenage son. They lie, they manipulate, etc. Carly is old enough to know what she did was wrong. I agree to disagree. Well, let me just ask you a question. Your troubled teenage son, was he on medications prescribed by doctors? Was he ever diagnosed as bipolar? Did he hear voices? I mean, every case is different, right? And every child is different. And I don't know the specifics of what you're saying about your son, and I absolutely empathize with you. But was he hearing voices since the age of 5? Did you give him access to a loaded weapon? I mean, I have a lot of questions, but I'm just saying every child is different, right? Ashley from Mississippi says, you need to road trip to Mississippi and experience this live. We will host you with all the hospitality and show you all the great parts of our state. Can you imagine Melanie in Mississippi, someone said? And then somebody else said, but if you order your iced tea here, it will be sweet. I like unsweetened iced tea. Do you guys have that there? Misbehaving in Florida, pointing out that psychopathy is not diagnosed until age 18 plus for a reason. Oh, and forget that. We read that one earlier. And Daisy said, documentaries about cases might as well be fiction. I agree. That's why I'm not watching the Mackenzie Shirilla documentary. And what I was going to say to you is Mackenzie Shirilla, who was 17 years old, who was convicted of intentional murder for her boyfriend and her friend who was in the backseat by intentionally driving something like 100 miles per hour into a building. She survived. The car was mangled. The verdict was that she intentionally did it. It was a bench trial. And the judge in that case sentenced Mackenzie to 2 terms of 15 years to life. Again, different state, Ohio, which technically, and I am not saying that this will happen, but technically under the law, under the way the statute's written, she could technically get parole after 15 years by the time she's like 33. I know all of the attorneys in Ohio said it will never, ever, ever, ever happen. I'm just saying, I'm pointing out the discrepancies in the way that minors are treated in different states. I turned off the documentary too, but I also did not watch the Mackenzie Shirilla trial. And I see so much screaming online about this girl and how horrific she was. And admittedly, I know nothing. I'm coming in like I know nothing. And I'm wondering if it would be worth watching the actual trial. It's only 5 days. If you guys want to watch the trial, I couldn't find it. I did like a little search on the tubes of you with all of the free time that I have in the middle of graduation season, wedding season, prom season, all of that. Thank you, Candy's Life. I'm going to actually copy that after I can confirm the address. If anybody wants to write to Carly, thank you. Would it be worth rewatching that trial if we can find it? Was it live streamed? And I'm not talking about, I don't know if there was a civil case too, but the actual criminal trial. I think it was 5 days long. Me too. I would rather watch the trial than the documentary, and then form an opinion because I don't know anything about it. Oh, nobody can find it. Oh, nobody can find it. Aiden was looking for it too. So nobody can. Where did it go? Didn't Court TV rewatch? Didn't they broadcast the trial live? Team Brittany says I've seen it. Don't. But I like to come to my own opinions about a case by actually watching the trial instead of watching some documentary. We know how documentaries go. They're not accurate. They leave so much stuff out. Keep her where she is. Yes, I'd like to see the trial. Well, apparently nobody can find it, so I don't know. Somebody's saying it was never televised. Okay, well, I guess that ends that. I'm just, because we see this all the time. We see people spewing hate online and everywhere about things that they don't know anything about. And maybe 90% of these people didn't watch the trial. I thought it would be an interesting rewatch, but I just don't think it wasn't public. It was from 2023. The trial happened in 2023. The Netflix documentary just came out recently, which is why there's like renewed interest in it. You know what I'm saying? But did anybody watch it streamed live in 2023 is what I'm saying. Yeah, her post-conviction jail calls are troubling. I've heard a little buzz about that. Only the sentencing and verdict were televised? Okay. So the trial wasn't televised, so we can't watch it anyway. All right, well, that ends that discussion. Thanks for telling me. Desiderata said, popping in quickly to say, I'm missing you, Melanie. We'll be back for a replay later. We're 95 degrees Fahrenheit in central Canada, staying hydrated. Love you, all. All right. Oh, I love you too. Thanks for tuning in from Canada. I don't know. I'm hoping the Habs can pull it off against the Canes. I'm really sad about the Avalanche getting swept. And yes, I have ordered my Las Vegas Knights hat. It will be here soon, probably before the first game of the Stanley Cup Finals. It's very exciting. John Tortorella is the coach for the Las Vegas Knights. Playoff hockey season is my favorite season of the year. And today it's Dave Matthews. John Tortorella coached the Rangers. John Tortorella hasn't been to a Stanley Cup for 20 years. And John Tortorella has only coached the Las Vegas Knights for like the last 20-something games. And he's taken them to the Stanley Cup. It's very exciting. But I'm also rooting for the Habs, so I just don't know what I'm going to do. Maybe I'll get hats and just alternate the hats. WKYC Channel 3, YouTube is supposed to have the trial. I don't know. We'll have to see. Thank you for that, Noodle Mama. Law Junkie says, in my opinion, not to victim shame, but mom had a loaded pew-pew unsecured in her nightstand with a child in the house, a heavily medicated teen dealing with issues. I get she lost her life, but she still shares blame. I can't disagree with you. Megan says she should be in a place like Lindsay Clancy. And those places are like not like, the Ritz-Carlton, to say the least, right? Justin Mum with MS says, wicked ick at the judge and the prosecutor. Sorry, not sorry. You don't need to apologize. Thank you for being here for 5 months. Bridget says, Melanie, I love you when you say Bridget. Bridget. Brigitte. Oh, is that how you pronounce your name too? Bridget is what you're saying. I get you. I get you. Oh, please. All right. I guess we will follow up on this when we have a decision from the Mississippi Supreme Court. I think it sounds like under the plain language of the statute, that's where the Supreme Court of Mississippi may go. And they may say she's entitled to parole. But looking back at the sentencing hearing, it seemed pretty clear that the jury made that decision based on no parole, because with parole was their other option. And so it was something. Can we watch the Anna Kepner trial? It's going to be in federal court. And I don't even think it has a date yet. But it is Anna Kepner's stepbrother's trial. Federal court never has cameras in it, sweetie. I'm sorry. Thank you, Happy Rage Crocheting. I hope you're crocheting some fun stuff. Oh, you want to do the affirmation of the day? Let's do that. Thank you, Mitchell, for reminding me. Today is Wednesday, May 27th, 2026. We did not even get to do our motivational quote of the day because we jumped right into, I wanted to jump right into the briefs because I only did a half an hour before court started to give us a little bit of time to go over the briefs. Okay, here we go. Wednesday, May 27th, 2026, our motivational quote of the day is from Ronald Reagan, who said, the greatest leader is not necessarily the one who does the greatest things. He is the one that gets the people to do the greatest things. That's so funny because we were talking about that the other day when we gave Spencer Pratt a little bit of time because I thought his interview with Billy Butch was really great. And so many people, not so many people, one or two people was like, oh, I'm so disappointed in you. How could you platform Spencer Pratt? I'm like, I don't know. I thought Billy Butch did a good interview. Are we not going to like listen to what the guy has to say? He's running on a safety platform. He's got the angry mom demographic, and nobody knows the angry moms better than we do, huh? The greatest leader is not necessarily the one who does the greatest things. He is the one that gets the people to do the greatest things, right? You hire a cabinet for a reason. Spencer Pratt's a grifter, people were saying. I'm like, I don't know. Maybe he was grifting when he was selling crystals, but to me, he sounds like a common sense platform. I don't know. I don't even live in LA. All right, here we go. But I wish I did. Empowerment card of the day. Ooh, we're running low on the deck. I keep saying that, and I keep saying I got to order a new deck, but I didn't do it yet. But I will. Hang on. Oh, there's a bunch left. Let's see. Because who doesn't need a little empowerment? We all do. Of course we do. You want to do the Karen Reed? Let's do the Karen Reed hearing a little bit later. I don't want to do it in the same stream as this. I think I want it to get its own stream. Here it is, your empowerment card. A woman is unstoppable once she discovers her worth. What? A woman is unstoppable once she discovers her worth. There it is. Debbie Joe. Angry moms are just one scrivener's error away from an angry mob. Girl, you win the internet today. Hold on one second. Well, gee, I guess somebody, Trial Channel was able to get it. So why don't we watch it together? Let's see what time. Right. Zoe said, can't be a grifter if no one buys them. Buyer beware is a thing, people, right? Caveat emptor. I remember that from an old Brady Bunch episode. Doesn't everyone remember the caveat emptor Brady Bunch episode? Can't be a grifter if no one buys them. Buyer beware is the thing, people. If you want to buy crystals, buy crystals. If you don't want to buy crystals, don't buy them. It's not that complicated. Right. No, I love Trial Channel and I love restreaming them because they like it and they allow it. Some channels are happy when you promote them because it helps their subscriber base and everything, you know? So let's say today it is 2:45. It is Wednesday. I have some things to do. Let me just see how long it's going to take me to do them. Let's see. Who will come on here? The guy I'm dating, says Bab, PSP, is neighbors with Aaron Spencer. Gotta go ask him if he'll come on here with you. I don't think Aaron Spencer should make any appearances before his trial. I wouldn't allow it. Or are you talking about having your boyfriend come on the channel? Yeah, I got to be careful with stuff like that because I can't vouch for who people are. It is now 2:45. How about we come back? What time do you want to come back? Melanie, after dark. Let me just check the docket. Hold on one second. Oh, please. I also found out too late because yesterday I was in an oncology ward all day. Not for me, but still somber day, all day. I didn't check my emails, and I think there was a hearing yesterday in Sean Johnson, Rosemary's Capiccio. Does anybody have that hearing posted anywhere? Because Rosemary's Capiccio says that she found some text messages in Proctor's phone that indicate that he could not believe that he was cleared to become a Massachusetts State Police officer. And so I think there was a hearing on that yesterday. The Trial Channel loves me. Thank you. Does anybody have that hearing? because I would be interested in doing that as well. Okay. And what day is it again? Oh, for the love of the traveling Mary. It is Wednesday. It is, I'm going to say, and Elise has all the papers. Yeah, but what I wanted to do was to watch the trial. I wanted to watch the trial. Farwell does not have cameras in the courtroom because that's federal court. So can't do that. I have to make a quick decision here. Melanie, did you get my email about an idea for a members only live show? It may be buried in emails, but I will look for it, Michelle. Thank you. It's hard for me to plan members. It's just hard for me to do anything right now. It's such a busy time of year. Mackenzie was not covered gavel to gavel. Okay. All right. Oh man, I got so many things to do. Hold on. How long is this hearing? It's 27 minutes. For those of you who didn't see it, I'm going to just show you a picture of, oh, well, I guess we can just go here quickly. To get a live shot of the House defendants. Let me pull this up for you so you can see it. Thank you, Trial Channel. I mean, they're there. Higgins is a shadow of his former self, if this is indeed Higgins. They all showed up. Chris Albert, Colin Albert, Jen McCabe, Matt McCabe, Brian Albert. And that's supposed to be Brian Higgins. He's lost a lot of weight. And wow. I mean, just wow. All right, here's what we're going to do. I'm going to jump off the air now and see what else I need to do. I got to talk to like 14 people in my family to figure out what else I have to get done today before doing that. But just please keep checking back. Make sure all of your notifications are set to all so that you will get the notification. If I can do this later, I will. It's not AI. They're sitting in the courtroom. They're literally sitting in the courtroom. This is a live video. It's a live video. Looks much healthier.
July 13th.
I mean, no shade, but Brian Albert looks like he aged a little bit. Right? I don't know. I can't let you know if I get your email, please and thank you. I get hundreds of emails a day, Noodle Mama. Hundreds, literally. Like I cannot respond to all of them. I cannot. I try, but I am an imperfect person. I fully admit that I'm imperfect when it comes to emails. I just can't. All right. Make sure you have all your notifications set. Make sure that you like the stream. Make sure you support the stream. Make sure that you hype the stream. Do all of the things. Would I like to cover this? Yes, of course I would. Do I have a million things to do right now because graduation, prom, weddings, everything? Yes, a million. Do I have a person that I need to take to chemotherapy and infusion therapy? A lot? Yes, I do. So just make sure your notifications are set. I got a lot of things going on right now. I'll try and do this later, but I can't promise. All right. Stay cool, stay kind, stay classy. Justice for Carly Gregg. I personally am of the opinion that I do not think that children should be locked up forever without ever having the chance of ever getting parole, especially if and when they have a psychotic break brought about by perhaps medications that are being freely prescribed to children without on Zoom without any, follow-up or anything such as like that. Okay. So stay cool, stay kind, stay classy. Don't believe everything you read on the internet. Thank you, moderators. I love you so much. I could never, ever, ever do this without you. You are the greatest. And I can't promise anything right now, but all I can say is I will try. Go Knights, go. Go Knights, go. I got my hat's on the way. It's on the way. I love John Tortorella. I love the fact that he had to pay $100,000 fine for the last time he refused to speak to the media and do the handshake. And so last night when the Knights got their trophy, I'm thinking, first of all, why is Torts wearing a tie with the Avalanche colors on it? Like that was a big misstep in my opinion. Second of all, he did speak to the press. Emily Kaplan got her interview. They did the handshake, and I just love how all the players from both teams were hugging each other. It was such a sentimental moment, wasn't it? I just loved it so much. All right, you guys, I love you so much. I will see you really soon. I just don't know when, but if I don't see you soon, I'm gonna die. So I'm gonna be back here soon. I love you guys. Peace. Later. Oh, wait, should we have Bang Bang play us out? Of course we should. Take me off any public televisions, put the earmuffs on your children, and let's have Bang Bang play us out.
I'll call this Bang Bang.
Can you hear it?
I will fuck you up. I will beat your ass. I will fuck you up.
Bye.
Pull up, bitch.